or hearing?
Group 9, my lord. It was appear. It was
Group 9, I don't have determination.
Yes, my lord.
It's unauthorized occupants act matter. Then group 9, I don't have determination. Yes. Please give.
My lord, may I have any indulgence to mention this matter?
Please wait, I'll come back to you.
Yes. Lordship, kindly to mention a matter. It's a new motion matter. I've mentioned it in the slip.
Please give.
Lordship, some urgency is there. They've initiated recovery proceedings, Your Lordship. I mentioned
Mention
it
the ground
the previous month also.
My lord, may I?
My lord, there is a matter. The department is continuously forcing us to repay the amount.
You mentioned the grounds of urgency. Give the notice. Yes. Give it. Yes, sir.
I would like to mention for the item number 392 December monthly list into the daily list. 392 for hearing.
For hearing matters, please wait. Yes.
My lord, may I be permitted to mention 3 Jalpaiguri matter, my lord? Same kind of matter, my lord. We are ready to pay the bond, but it could not be taken up before the Jalpaiguri bench. My lord, it may be listed this week, though my vehicles are confiscated, my lord. I can't release my vehicle until I pay the bond. So that is the reason, my lord. This matter was filed here.
We are allowed to mention 2 matters. Actually, one matter, the matter was already heard in the month of January 2025. An interim order was given in our favor. We have paid the 10% of the payment by the social. Even after making that payment, a recovery has been made. That is one matter. And the second matter is the matter is not yet listed. It is pending before the court. It has not been there in the list, but recovery action has been taken.
You have mentioned the grounds in both. Please give. They can indeed be
My lord,
urgent. Please give hearing matter. Let us see. Yes.
My lord, motion matter, some urgency, my lord. 268 item number.
What is the urgency?
My lord, my bank account has been attached, my lord, and I'm a T firm, and I want.
You have given notice to the.
Yes, my lord. All notice I've given.
Give notice again. Give notice again. It will appear.
Well, I've given notice and come.
You please
it is
give
appearing
notice
already. Appearing 268, my lord.
Am I not clear? I have said give notice again and come. Please give the slip. It will appear, but give notice again that you have mentioned today.
Okay, my lord.
Two 249 দেখুন দিদি ওটা ভুল হেডিং এ অ্যাপিয়ার করছে 249 টা কালকে ঠিক করে দেবেন 249 নাজমা রয় ওটা ইয়ে আনঅথরাইজড অকুপেন্টস অ্যাক্টের মামলা ওই হেডিং এ দিয়ে দেবেন এখান থেকে কেটে দিন ইট উইল বি কারেক্ট ইয়েস give including here.
Lordship, may I be permitted to mention a matter from the court of Justice Parthasarathi Chatterjee. It was appearing under the heading upgraded matter in Court 7. There is certain urgency. It is in the stage of hearing. This is a hearing matter. Lordship, Group 2 education matter. The petitioner's registration. He was in second year MTech course. Registration was cancelled before third semester. No reason was given. The petition was filed. Affidavits have been exchanged. The university is against the petitioner, but the institution is in support of the petitioner. Now, Your Lordship, it is pending for hearing.
Very well. Give mention your grounds of urgency.
I have mentioned to email. I will start once again.
Mention the grounds of urgency in the notice.
I have mentioned.
দেখুন দিদি এই give it. Write the grounds of urgency of written. Yes.
Your Lordship, may I be permitted to mention a matter? Your Lordship, this is a matter in which my appeal under 107 was rejected on the grounds of delay. Now the urgency is that they have issued recovery notices to me. My Lord.
Give it. Give it.
Grateful, my Lord.
Petitioner wants to expunge your name from the petition. Then how will the petition be maintainable? So who will be the petitioner then if the petitioner's name is expired? The other one you want to withdraw. Take instructions properly. You want to withdraw the writ petition. Give it যেটা withdrawal এর জন্য আছে ওটা non prosecute but you bring instructions with in regard to that from your client.
But may I mention one listed motion 2022, my lord. This is for inclusion.
Give it.
And
Yes.
another is hearing whether, my lord,
Give it. Give it. Yes, please call the list.
My lord, for the petitioners, petitioner want to withdraw the instruction.
লিখে নিন।
Because the constitutional
You filed the opposition.
no, my lord, we are praying for extension because constitutional validity is on the check.
Very good. This matter is appearing under the heading extension of interim order.
But I beg to appear on behalf of the petitioner.
দাঁড়া, দাঁড়া।
Things are complete only in one of the matters. The
Lord-
other
'46 expired, my lord, sometimes in 2016. In the meantime, there was an amendment to section 11 subsection 7, which amendment we will place before your lordship. And my lord, based on this amendment, what the income tax authorities did, they, my lord, renewed 12 AA but did not give me 1046. Now, my lord, the contentions between the parties continued. We made representation. Lord, we had come up before this court in an earlier round of litigation where the court directed the income tax board to consider our application for registration under 1046. Now, my lord, the board passed an order saying that I am entitled to registration under 1046 by surrendering 12 AA with effect from 2020, a date in 2020, but not from the stage of 2016 onwards. Not 2000, between 2016 and 20, they will still not take registration under 12 AA. That's the dispute, Lord, with which the first writ petition is filed in 2024. And Lord, during the pendency of this writ petition, directions for filing affidavits were given, no interim order was considered. During the pendency of this writ petition, Lord, some demand was raised on account of penalty. So, Lord, the second writ petition was filed. And that is the second writ petition, where, Lord, my learned friend hasn't filed the affidavit. But, Lord, if your Lordship holds that, Lord, I am entitled to 1046 with effect from 2016, 2020 conceded, because the department itself also says that 2020 onwards, I am entitled. So, the dispute is now narrowed down to 2016 to 2020. This is, Lord, the situation.
Let this matter, my lord, when the assessee first applied, then I had given him benefit and the board because the statute provided so. But in 2017, on 24th of June, there was an amendment by which it was stated in the statute that only one provision he can take. That is either section 12 AA or section 1046. So, Millard, when his term expired, the exemption granted expired, he applied for a fresh. And that was refused because the statute did not provide so. The statute did not provide so, that is admitted by them also. But later on, the statute was again amended in 2020, where we again gave them, provided they surrender one of the benefits. Now, Miller, the dispute is that they want a retrospective operation of that amendment for the period when the amendment was not there. When the statute barred me from giving him both the benefits, Miller, that time I cannot give it. So he wants a retrospective operation of the amending statute in 2020 to give effect to the 2017.
Then I'll hear Mr. Corpus. Yes. On the retrospectivity.
Yes. Lord, if your Lordships kindly take the Income Tax Act, Lord. I am not troubling your Lordship with the facts because these facts are, Lord, admitted. There is no difficulty. I'll only place the order of CBDT and then. But before that, may I just place the Act provisions of the Act. First, Lord, come to section 10.
So we are taking this 2024 one.
Yes, kindly take 2024 one.
Because
That readings are
2025,
complete.
I have not been asked to file an affidavit in that. They made an application before the court for an interim order, which was refused.
So 2025 also concerns the same dispute
But
as
I-
to whether retrospective operation.
It is connected. It is connected.
So
But
if
I-
this is decided, this will stand decided,
This
or
will stand decided.
so this
Because they
In-
have in the second writ petition asked for stay on the demands made by me
on the
as
basis of.
the basis of that.
So this is the main thing.
And
Yes.
in any event, the demand that they have raised, in the penalty demand that they have raised, is in respect of the financial year 2023-24. So 23-24, according to their own order of CBDT, can't stand, because if I,
So Mr. Datta, if 23-24, why should not the exemption be granted?
That writ petition was never moved. So I had no occasion to deal with the.
Very well, then I am severing it for the moment. Let
Very-
us concentrate on
very-
2024. I am not deciding this today.
Lord, first come to section 10.
Section 10.
Yes. Section 10, subsection 46. এটা হবে না, এটা পুরনো। Lord, I don't know which year your lordships have. This will be in the old. नहीं, Judge साहब, हाँ।
না 10 আগে দেখা
ও দিয়েছে, ও দিয়েছে।
Yes.
Lord, 10 subsection 46.
1046. Yes.
Any specified income arising to a body or authority or board of trust or commission by whatever name called, other than those covered under section 46A or a class thereof, which has been established or constituted by or under a central, state or provincial act, or constituted by the central government or a state government with the object of regulating or administering any activity for the benefit of the general public, is not engaged in commercial activity, and is notified by the central government in the official gazette for the purpose of this clause. Then section 10, Lord, deals with exemptions. Your lordships have, Lord, seen, Lord, section 10. Sorry, Lord, I should have placed the body of section 10 first before coming to subsection 46. 10 এত বড় section.
Exemption section.
Exemption section.
Yes.
So, Lord, this is
These-
one of the
the-
grounds on which,
The
Lord, the
clauses
exemption.
mentioned therein will not be included in income.
Yes. Now, Lord, so far as the petitioner assessee is concerned, it is a welfare board. It's a welfare board for, Lord, benefit of the construction workers. They are, Lord, they protect the interest of the construction workers. It is not run on the for profit. And Lord, this is, Lord, under a statute called the Building and Other Construction Workers. Lord, this is the statute. This is the statute. The Building and Other Construction. This is the central statute. Basically, Lord, when a construction takes place, they collect a percentage for the benefit of these construction workers, and out of which they are benevolent, Lord, for benevolent purpose, this fund is utilized.
Yes.
Now, Lord, your lordships may kindly have a look at page 181, page 184, where, Lord, in 2014,
Page 184 of the writ petition.
yes, Lord. No, I'm sorry. Page ta koto? Kindly give me 1 minute. You're looking at 2024 writ petition.
Yes.
তো এই exemption দিয়েছিল under section 1046.
39.
Page 39, page 39. বলছে 39. No. 34, 34. I'm sorry. No, 34 to not.
34 is pleadings.
No. 23rd December 2014. Yes. Please come to page 41. 41.
41.
Yes. There being two writ petitions, the paginations, Lord, are
Yes, page 41. We are taking
24.
2024.
24 first. 24 first. First writ petition.
Because the pleadings are complete.
Yes.
There will be problems in
ওরে ভাই ঠিক আছে কি ব্যাপার 23rd December 2014 says in exercise of powers under 1046 of the Income Tax Act, the central government hereby notifies for the purpose of this clause West Bengal Building and Other Construction Workers Welfare Board, a body constituted by the government of West Bengal in respect of the following specified income arising from the body. And then, Lord, it says this notification shall be applicable for the financial years 2011-12, 2015-16. So, Lord, kindly mark it. In 2014, Lord, the notification is given retrospectively with effect from 2011-12 to 2015-16. Now, Lord, this being the position, Lord, in the Income Tax Act,
yes,
an amendment comes with effect from 1st April 2015 to section 11. If your lordships kindly come to section 11.
Section 11.
Yes.
Yes.
Lord, section 11. Please come to section 11, subsection 7.
Seven.
Yes. Where a trust or an institution has been granted registration under section 12AA or section 12AB or has obtained registration at any time under section 12A as it stood before its amendment by the Finance Act 1996, and the said registration is in force for any previous year, then nothing contained in section 10 other than clause 1, clause 23C and clause 46 thereof shall operate to exclude any income derived from the property held under trust from the total income of the person in receipt thereof for that previous year. Then kindly read the proviso. Provided that such registration shall become inoperative from the date on which the trust or institution is approved under clause 23C of section 10 or is notified under section clause 46 of the said section, as the case may be, or the date on which this proviso has come into force, whichever is later. Now, Lord, this amendment came with I think with effect from 2020, this proviso.
Proviso, I think, came from 2024.
2024.
Proviso shows 2024. There is
Yes.
a change in the proviso
Yes.
by the Finance Act 2023 with effect from 1st April 2024.
But Lord, this the first part 7 was in 2020.
38A.
This clause 7, it is from 1st June 2020. Now, my lord, what it says in substance, my lord, my understanding, humble understanding is you can't have both. Therefore, you have to opt for one. Either you take and retain 12 AA or you retain 1046. Now, my lord, as on the date, we had both the certificates. I'll give your lordships, my lord, the two dates. Lord, 16th September 2011, Lord, we obtained the 12 AA certificate. 16th September 2011. This is at page 40 of the writ petition.
Page 40.
Yes.
Yes.
And Lord, 23rd December 2014, we got, Lord, that 1046, which I have already
Page
shown to you.
41.
Page 41. আমরা এটা দিচ্ছে with effect from 2015 this amendment. সেই amendmentটা কোথায়? Section 7.
Yes.
Now, Lord, immediately after this exemption, which was allowed under 1046, expired on 31st March 2016. Lord, this exemption, your lordships will get, Lord, at the relevant page, page 41, I think.
Page 41 is the 23rd December 2014 notification.
Yes, the lordships will find it is up to 2016. Kindly take
Yes,
paragraph
11-12 to 2015-16.
So 15-16 Lord ends, Lord, on 31st of March 2016. So Lord, this was valid till 2016.
Yes.
Now Lord, on 8th of April 2016, the lordships will get this at page 43. Lord, we made an application for renewal of 1046 registration.
Right.
Page 43.
8th of April 2020.
Lord, this is page 43. Yes.
2016. Yes.
8th April 2016 it will be. Sorry, my lord, that 16 is not there.
Yes,
it
it's
should be
there
16.
at page 44.
Yes. Yes. Now, my lord, after ঠিক আছে, ঠিক আছে, ঠিক আছে. Now, my lord, then Lord, on 24th July, which is at page 47,
Page 47.
Lord, it was this was not allowed. In fact, they said, kindly see, Lord, paragraph 3. It says, as per amendment by the Finance Act 2014, with effect from 1/4/2015, subsection 7 of 11 has been inserted, owing to which, where a trust or an institution has been granted registration for the purposes of availing exemption under section 11, and the registration is in force for the previous year, then such trust or institution cannot claim any exemption under any provisions of section 10. Other than that relating to exemption of agricultural income and income exempted from so and so. Kindly see the actual text, Lord, that is set out, where a trust or an institution has been granted registration under clause B of subsection 1 of section 12A, or has obtained registration at any time under section 12A, as it stood before amendment so and so, and the said registration is in force for any previous year, then nothing contained in section 10 other than clause 123C thereof shall operate to exclude any income derived from the property held under trust from the total income of the person in receipt thereof for that previous year. Now, Lord, the text will show, Lord, it only takes into consideration in a case where 12 AA is applicable, not 1046. This amendment, which came on 1st April 2015, it says that where a trust or a institution has been granted registration under clause B of subsection 1 of section 12A. So, Lord,
So, prior to this coming into force, you had already been granted a an exception by way of a notification dated 23rd December 2014,
my lord.
where you were enjoying exemption under 1046.
Therefore, Lord, my contention was that this amendment did not affect my right at all. Because at the highest, you could have taken away my 12AA. I was not availing of 12AA. In fact, till date, I have not availed of 12AA. So, my lord, I was seeking renewal of registration of 1046, saying that this provision has no application so far as I am concerned. This contemplates where an entity is already registered under 12AA and is trying to get a registration under 1046. That is not what my case was. Now, Lord, what happens is, after this, I will not trouble your lordships too much on facts. Lord, the amendment of 2020 comes.
No, but Mr. Kaur, just for my understanding, it says your registration was under 12AA. Your registration was under 12AA. Now, this section says where a trust or an institution has been granted registration under clause B of subsection 1 of section 12AA or has obtained registration at any time under section 12A. So 12AA is a section under which you get registration. 1046 is not for registration.
Exemption.
It's for exemption. Then if you are registered under 12AA, then in that case, nothing contained in section 10 other than 23C shall operate to exclude any income. Therefore, the moment this provision says that if you are registered under 12AA, then exception is only section 1023C. Excepting that, none of those clauses will apply and exempt you.
Lord, this, in my humble submission, does not take into consideration a situation where an entity is registered under 12AA and was also, Lord, enjoying 1046. Lord, my humble reading of the fact is that legislature understood their mistake. And that is the reason why they issued a clarification, which I'll show, Lord, in the Finance Act immediately. Because, Lord, obviously, when an entity was enjoying, despite being registered under 12AA, there was no bar. As on the date, I was enjoying my registration under 1046, there was no bar. The bar was created or introduced, Lord, at a time when I had both. I was registered under 12AA and, Lord, I was also, Lord, enjoying my exemption under 1046. Now, Lord, in the process, the 2000 Finance Act comes. Lord, there is I've handed over, Lord, the Finance Act. Kindly, Lord, see if it is there.
Finance bill.
Finance bill. Sorry. Finance bill. Lord, please come to internal page 29.
29.
Lord, it talks about rationalization of provisions relating to trust, institution and funds. Has your lordship found that? It says amendment of subsection 7 of section 11, etc. Section 11 of the Act provides for grant of exemption in respect of income derived from property held under trust, charitable institution, etc. Please come down to Lord 1, 2, 3, 4th paragraph. It has been noticed. Has your lordship found that? That
Yes.
there is some anomaly by providing exclusion to institution or fund registered under clause 23C of section 10, but the same exclusion is not available to entities claiming exemption under clause 46 of section 10, which are established or constituted under the Central or State Act or by a central or state government. Such entities are thus not able to get notified under clause 46 of section 10 if they are holding registration under section 12A, 12AA. The anomaly pointed out above needs to be addressed. However, as the provisions relating to charitable entities constitute a complete code, and that once any trust or institution has voluntarily opted for it by obtaining the requisite registration, it flows that conditions in relation thereto should be complied with, and the option of switching at the convenience should not be available. Accordingly, while request for exclusion of clause 46 may be acceded to for exemption thereunder, even in those cases where registration under section 12AA or 12A remains in force, there should be only one mode of exemption available, and also that the switching may be allowed only once. so that such switching is not done routinely and also it remains efficient to be administered. So, my lord, this anomaly was taken note of. And they said this was clarified that one switching will be permissible. Therefore, you can give up your 12 AA and come under 1046. And our contention is that, Lord, this is clarificatory. This is not something which is creating a right, Lord, by giving this clarification. And therefore, Lord, the proviso comes into effect, that 11.7 proviso is based on this. Now, Lord, kindly see the order of CBDT. Lord, I just take your lordship straight to the order of CBDT that starts at page 78.
The market.
Lord, it starts at page 78. Lord, paragraph 2.1, 11.7 is quoted. Your lordship's.
Yes. Got it.
Then, Lord, 2.2, in view of the amendment to 11.7 of the Act, so and so of the Act cannot be issued prior to financial 2021, as it was barred by statute. Therefore, your application for notification under 1046 of the Act cannot be considered for the period prior to financial year 2021. Then, Lord, the contentions are dealt with. Paragraph 6.2.1, page 80.
Yes.
Earlier, in this regard, it is stated as under. Earlier, West Bengal Building and Other Construction Workers Welfare, etc., granted exemption before the subsection 7 of 11 of the Act inserted, with effect from 1st April 2015. It may be noted that an amendment was brought in section 11.7 of the Act by Finance Act. In view of the amendment brought in section 11.7 of the Act of Finance Act, the applicant is eligible for exemption under 1046 of the Act with effect from financial 2021 cannot be granted retrospectively. However, your averments that your application for exemption under 1046 of the Act has been kept pending for over 7 years by reviewing the other exemptions of the Act is denied. It is regarded, in this regard, it is submitted that you had filed an application for renewal of exemption under 1046 by letter dated such and such. On perusal of the application, it was observed that West Bengal Building and Other Construction Workers Welfare Board was already registered 12 AA with effect from such and such. Factually, my lord, I don't think there is any dispute. Now, the only issue is that, Lord, they also concede that they can't stop, Lord, switching over from 2021. The issue is whether, Lord, I am entitled to renewal from the date, Lord, it expired. My
in view of the in-between amendment of 2015.
2015. Lord, whether I am entitled to, Lord, renewal insofar as this certificate is concerned. Lord, there are two aspects of the matter. May I just address your lordship? One is that, Lord, the legislative mandate, which is, Lord, explained in the Finance Bill, where, Lord, they clearly, Lord, understand the public hardship, because it was never the intention of the statute. That is how it is clarified. It was never the intention of the statute that, Lord, 12 AA should be held against the charitable and non-profitable organizations in rejecting their registration under 1046. And they should be given a switchover, the option for switchover. Now, Lord, this switchover can only mean the switchover at the relevant point of time, not a switchover in 2020-21. Why I say this? Because, Lord, this is basically a clarificatory. And if it is clarificatory, Lord, it will relate back to, it will become retrospective. And I'll cite, Lord, judgments on this. Lord, the other aspect of the matter is that, Lord, I, as an assessee, I know what is beneficial to me. If a statute, Lord, was prevailing as on the date of amendment, which gave me certain benefits, Lord, I am entitled to opt and keep that benefit, as has been explained. Now, Lord, what happens for this next 4 years, 2016 to 2020? Lord, despite the fact that I am not carrying on any business, I will be made to pay enormous amount of tax. Enormous amount of tax, because the money that I am receiving for the benefit and as a welfare board, Lord, will be treated as an income in my hand. That defeats the purpose for which, Lord, I am set up. As a governmental organization, I am set up, Lord, for certain beneficial for the purpose of implementing a legislative mandate. Now, Lord, that's get defeated. Lord, is the workers' money which will go in tax. So therefore, Lord, today, if that money is paid, the pension and other dues to the workers can't be paid. I can understand, Lord, as a businessman, I have made some profit. And I'm running a business organization, which I am not. And that is one of the reasons why 1046 was granted at the initial stage. So, Lord, the whole purpose of a legislative mandate granted, Lord, under that 2016 Act will stand defeated. And that was never the intention of the amendment of section 11, subsection 7. Telangana charge. Lord, this issue fell for consideration before, Lord, the Telangana High Court. Okay. Huh? Very angelical. Sorry. No, that's between friends. Your Lordship and me, we don't come in between. Lord, for the facts, if Your Lordship will not kindly come to Lord, take the first paragraph. By these two separate petitions, the petitioners are questioning the action of the respondent, in particular the first respondent, in not notifying the petitioners under section 1046 of the Income Tax Act 1961. Hence, these writ petitions are being disposed of by common order. Then, Lord, the Telangana State Pollution Control Board is the petitioner, and Andhra Pradesh Pollution Control Board is the petitioner in such and such. Both the petitions are constituted by the state government under section 4 of the Water Prevention, etc. Is the case of the petitioner that TSPCB, that is on the application the prescribed authorized second respondent granted approval under 1023C 4 of the Act with effect from the assessment year 2014-15 onwards. Similarly, it is the case of APCB that prescribed authority granted approval under section 1023C Act with effect from assessment year 2010-11 onwards. It is a common case of the petitioners that though the petitioners were approved by the second respondent and granted exemption under 1023C of the Act, the third respondent denied the benefit of exemption on its income under the Act for one of the other reasons, and the matters are pending consideration in appeal before the appellate forum. The petitioners contend that Parliament Finance Act 2011 inserted subsection 46 of section 10 with effect from 1/6/2011, and that the said provision being more opposite to the activities carried on by the petitioners submitted application in 2017 and 8 March 2017 respectively for being notified under section 1046 of the Act that the petitioners satisfy the conditions specified under section 1046 of the Act, and similarly placed pollution control boards of the other states have been notified under section 1046 of the Act. And despite that, the petitioners making application for issue of notification under 1046 of the Act, which will entail the petitioners to avail exemption on their income, the said request of the petitioners is not being considered, and the petitioners are not notified under 1046 of the Act. This will not happen prior to the finance bill, Then, Lord, and only exception is that here it was 1023, they wanted 1046. Then, Lord, the discussions are there. Can I please come to paragraph 19? We have considered the submissions made by the learned counsel appearing for the parties. Before adverting to the respective contentions advanced on behalf of the parties, it is necessary to take note of the scheme of the Act dealing with exemption under 1023C, 4 and 1046 of the Act. Then, Lord, the discussion proceeds, Lord, on consideration of the two provisions. Please come to para 29. On the I start from para 28 in fact. Applying the principles deduced from the above to the facts of the case, it is to be held that the power to withdraw is prerogative of the respondent, and the assessee cannot seek to surrender the approval granted to it under 1023C4 of the Act, would amount to giving a restrictive meaning to the word withdrawal to say only at the behest of the prescribed authority. This, in our considered view, would run contrary to the harmonious interpretation of the provisions required to be undertaken. On the other hand, if the stand of the respondent that once the exemption is granted, the same can only be withdrawn by the authority granting exemption, and such withdrawal cannot be sought to by the assessee is accepted, it might result in an assessee who is given situation having sought for grant of approval under section 1023C4 of the Act continuing to retain such approval even though he is not complying with the provisions of the Act for availing exemption. It is understandable that in normal circumstances, as it is, the assessee who would seek for grant of approval in order to avail exemption may not by itself seek for withdrawal. But in a given circumstances where an assessee decides not to avail exemption and chose to surrender the approval obtained by the the prescribed authority, it cannot be said that the Act does not provide for surrender, and also that prescribed authority lacks power to accept surrender and exercise the power of withdrawal conferred on him. This interpretation results in the assessee being compelled to continue with such approval obtained. It is to be seen that no assessee can be compelled to continue any exemption if it intends not to avail for the same. It is always open for an assessee to arrange its affairs in a manner which it feels it would be beneficial, and it cannot be compelled to continue its operation activities in a particular manner which would be prejudicial to its interest. If the said stand of the respondent is accepted, it would lead to an anomalous situation, results in incentive to be dishonest rather than rewarding the honest. In juxtaposition, section 1046 of the Act confers power of the central government to notify in the official gazette any specified income of a body or authority or board or a trust or a commission not being included in its total income, subject to complying with the conditions specified therein. Thus, once a notification is issued by the central government in official gazette specifying the income of an assessee not forming part of the total income, the assessee would be entitled to claim exemption on that specified income, and no discretion would vest on the assessing authority to examine the eligibility of the assessee to claim exemption thereon. Thus, the basic difference between the two provisions of the 1023 and 1046 of the Act is that while under this first provision, it is only a grant of an approval making an assessee eligible to exemption without a certainty of exemption being allowed on any income, since it is subject to scrutiny, and later provision confers benefit of automatic exemption. Thus, under section 1046 of the Act, there is a certainty with regard to the claim of exemption. Then, Lord, the Supreme Court judgment is noted. that is 1997-11 SCC. Then 2001-9 is also noted. And then it says, in the facts of the present case, though there are two different provisions of the Act under which the petitioners can claim the benefit, mere fact that petitioners being granted approval under one, particularly provisions of the Act, namely Section 1023(4) of the Act, in our opinion, would not disentitle the petitioner's assessee to seek for being notified under a different provision, and it is for the petitioners to choose as to which of the provisions would be more beneficial. So, my lord, in so far as this judgment of the Telangana High Court is concerned, Lord, the issue was, Lord, they were getting benefit, Lord, under a provision,
23C.
and Lord, they were seeking, Lord, protection under another provision. The Telangana High Court says that it is the option of the assessee. If they are not earning, there is no income, then Lord, under which provision they would come, it is entirely for them to decide. Exactly the same thing is here. Lord, when we wanted the 12AA to be taken away, Lord, we want 1046. Lord, there is no reason why we should be held to 12AA for a period of 4 years, and for which we will have to unnecessarily pay tax. And Lord, on the retrospectivity, that 9711, Lord, that 9711, there is a judgment, Lord, which is on which reliance is placed by Telangana High Court. The Lordship just found, Lord, that paragraph 34.
Yes.
318.
CC versus Indian Petrochemical.
Yes, that is, Lord, that is a one-page judgment of the Supreme Court. I just, Lord, thought I'll just hand up. Other side. Okay. It's just 5 lines, Lord. If two beneficial notifications are applicable, Lord, I can always, Lord, opt for one. And amendment to section 11(7) couldn't have been a bar to that. It was never intended to be a bar. And Lord, on the retrospectivity, এটা দিয়ে দাও 2015 টা আগে দিয়ে দাও আচ্ছা Lord, I rely on a judgment, Lord, reported in 2015 volume 1 SCC page 1. আছে নেই তাহলে আরেক যেটা আছে অ্যাভেলেবল দিয়ে দাও এটা দরকার নেই যেটা অ্যাভেলেবল আছে দিয়ে দাও kindly give you 1 minute, Lord.
Yes.
2004 volume 8 আছে yes কোনটা আছে ওইটা আছে হ্যাঁ রাইল সিংটা দিয়ে দাও Lord, this is 2004 volume 8, same principle. I needn't multiply. There. আচ্ছা ঠিক আছে পরে এটা পরে উফ Lord, please come to paragraph 13 now.
Yes.
It is cardinal principle of construction that every statute is prima facie prospective unless it is expressly or by necessary implication made to have a retrospective operation. But the rule in general is applicable where the object of the statute is to affect vested rights or to impose new burdens or to impair existing obligations. Unless there are words in the statute sufficient to show that intention of the legislature to affect existing rights, it is deemed to be prospective only. Nova so and so. A new law ought not to regulate what is to follow, not the past. It is not necessary that an express provision be made to make a statute retrospective, and the presumption against retrospectivity may be rebutted by necessary implication, especially in a case where the new law is made to cure an acknowledged evil for the benefit of the community as a whole. The presumption against retrospective operation is not applicable to declaratory statutes. In determining, therefore, the nature of the act, regard must be had to the substance rather than the form. If a new act is to explain an earlier act, it would be without object unless construed retrospectively. An explanatory act is generally passed to supply an obvious omission or to clear up doubts as to the meaning of the previous act. It is well settled that if a statute is curative or merely declaratory of the previous law, retrospective operation is generally intended. An amending act may be purely declaratory to clear a meaning of a provision of the principal act which was already implicit. A clarificatory amendment of this nature will have retrospective effect. Similar, that switchover is implicit. They are just not explaining that this switchover is possible. So therefore, Lord, I am saying that I am entitled to the retrospectivity of my renewal from 2016 when it expired. It is not, Lord, creating a new right. It is not a new law. It's not a new law which is coming, Lord, and creating a new right. It is
only clarifying what was there.
And Lord, the intention is to restore, Lord, a situation which was already there, because they are saying this switching over is permissible. One time switching over is permissible. If the legislature feels that one time switching over is permissible, it was implicit, Lord, in the act when the amendment came into effect. So, Lord, I am saying, Lord, 2020 they concede. There is no difficulty up to 2020. Between 2016 and 2020, I said that as a matter of right, I am entitled. I think, Lord, the subject these are the points, Lord. This is a short point that I have. So far as the second writ petition is concerned, I just only want to say that for 23-24, they have not issued that penalty order. Assessment order is also in respect of 23-24, and penalty order is also in respect of 23-24. If your Lordship holds, Lord, in my favor, even if your Lordship upholds their contention that I am entitled to registration from 2020, that 23-24, that has to go, because, Lord, if I get a registration even from 2020, that can't be sustained. So, Lord, that's the second matter, but this is the principal point.
I shall come to the judgments. First, though I do not have anything to add more in the facts, but kindly take page 41 once. Page 41.
Page 41.
Page 41, your Lordship will see it is dated 23rd December 2014.
Yes.
And kindly see that number 2, the notification shall be applicable for the financial year 2011 and 12 to 2015 and 16. So therefore, when this notification was there, Millard, the amendment to the act had come into place. It was 15, 16. So therefore, while they were continuing with the benefits, the amendment came to place. It is not the case of the SSC that during the continuation of the benefit, I had taken away a portion of it. Millard, here, your Lordship will kindly, Millard, consider the submissions of the clarification given by the CBDT at page 78. The amendment took place on 1st April 2015.
Page 78.
So the amendment took place since this page your lordship has seen till 2015-16 they had enjoyed the amendment, enjoyed the benefits. But the amendment came into effect on 1st April 2015. So I have, my lord, not taken away the benefit from him, but I have allowed him to continue, my lord, till the expiry of this page 41, because it was a gazette notification. Thereafter, my lord, this 2015 amendment came, whereby the statute, my lord, barred me from giving him benefit under both. My lord, in the second notification, which was made in 2020-21, it was reintroduced and they were asked to either take one or don't take. But my lord, here the question would arise that if I do not have the powers under the statute to give him the benefits, how could I, my lord, have given him the benefits if the statute does not provide so? And the Gazette,
But Mr. Dasso, when this order was passed,
Yes.
this 2023 order, it was pointed out by Mr. Kaur that you yourself have said that from 2021 onwards you are entitled, page
Yes.
79.
that is so.
No, but then the second writ petition, what will be the basis of not granting exemption?
Because he did not apply for it. He straight away came to court. They want that everything should be given retrospectively, which I cannot give. If they, my lord, so far as this is concerned, my lord, so
From
far as they-
2020 financial year 2020-2021 onwards,
yes,
after
they
introduction.
are entitled to get. They are entitled to get.
So therefore, the second writ petition should not be a cause for concern now, because second writ petition takes into within its fold only that period which is post the 2020 amendment.
Yes.
So therefore, that should not be a cause for concern. This assessment order will then have to be interfered with.
Yes. But here the question is, my lord, whether if the statute does not provide, it does not specifically provide for any kind of interference or change of, my lord, this or rereading, reinterpretation, then will how can I, as an authority under the statute, give him the retrospective operation of the order by which, my lord, kindly see, my lord, with effect from 1st April 2015, provided that where the trust or
Page, where are you
page,
reading?
my lord, for 78,
Page 78, yes.
the second paragraph.
Yes.
In the matter, I am directed to state that your application dated 8/4/2016 for notification 1046 of Income Tax Act could not be processed as it was limited restriction 11(7) of the Act as it existed at that time. At that time. So when you made the application, the restrictions existed that time. Even that time, the clarification also did not come. Subsection 7 of section 11 of the Act inserted by Finance Act 2014 with effect from 1st April 2015 provided that where a trust or institution has obtained registration under 12AA as it stood immediately before the proposed amendment or under 12A as it stood before the amendment and registration in force of any previous year, then exemption under 10 shall not be allowed. So, Miller, there is no question of operation of this. Miller, either retrospectively, it has to come prospectively. So, Miller, this amendment, if I take it as prospective, then Miller, the amendment of 2020, how can I treat that as a retrospective? And a taxing statute, Miller, Only we shall consider, Millard, what is written in the statute. It has to be strictly construed.
Then what is the answer to this explanation or clarification given in the finance bill?
That is kindly see the date.
Is 2020.
2020. So in 2016, when they made the application for Millard extension, and Millard,
Do you have the finance bill of 2015?
2015
By which the 2015 amendment was incorporated? Because that will give the intention of the 2015 amendment.
Millard, kindly keep it under the day. I shall come back.
Tell me, in the meantime, Mr. Dutt also filed a report in the form of affidavit insofar as the second writ petition is concerned, clarifying this, because then in that case, after 2021, if they are eligible, then this matter can be solved. We'll be left with only one.
Yes.
The issue of retrospectivity.
I shall take instructions on that. I shall file the report.
Take
I shall.
written instructions will be
I
easier
shall
for all
file
of us. Because then in that case, this issue at least will be
Yes. One writ
check.
petition will be disposed of.
Absolutely. Absolutely.
We'll be setting apart one responsibility instead of
Yes.
having two writ petitions. This will be cleared off because this unnecessarily is pending.
Absolutely.
If this is the stand, because this stand is there, it appears that the stand is there.
Yes, in the form of CBDT order.
CBDT says from 2021, I am entitled.
Yes, page 80, 6.2.1.
Yes.
III.
Yes.
It clearly says, in view of the amendment brought in section 11(7) by the Finance Act of 2020, the applicant is eligible for exemption under section 1046 from financial year 2020-2021 and cannot be granted rest. So you are eligible for exemption here.
Yes.
If this eligibility is there,
Yes.
then there is no purpose in having this.
No, then what is my contention is that this eligibility comes from 2020-21.
Very well.
And it
At least,
doesn't travel back.
very well. That we will, that issue we will thrash out. We will thrash out. But
Yes.
so far as this is concerned,
The second writ
2021
petition
onwards,
can be disposed
then
of.
at least this writ petition will go,
Yes.
will be answered one way or the other.
Absolutely.
আরে ভাই 16 হবে কি 20 হবে সেটা তো ফার্স্ট রিট পিটিশনে ডিসাইডেড হবে তাই তো বলছেন তো পরেরটা আর কি করে থাকবে গোপাল বলছিল 200
लिखे नहीं तो दीदी manipulation. Although in the order dated Please be solved. This is post that. And in view of the language used by CBDT, I don't think they will have any case there.
And that is absolutely certain, because they are entitled to after 2020.
So at least after 2021, that part should be taken care of. Prior to that, whether they'll be granted or not, that wrestle you will have.
But the Finance Act 2020, which was cited before your Lordship, that gave a clarification regarding the amendment in 2020.
Yes, I understand. That is why 2020 you are eligible is what they are saying. Whether 2016 they are eligible or not, that we will sort out.
Yes.
That will be a legal tussle. But in view of this specific amendment, 2020 onwards, there should be no problem. So at least on that ground, you let it go.
The report was called for the PCIT by the board, PCIT exemption. That report was submitted, forwarded. They are doing.
Let us see if this can, because at least one we will get through. Other we will, at a legal point, we shall thrash it, whether retrospective or prospective, that we can thrash out.
Yes. There are principally two issues in the petition, my lord. One is that ITC has been denied to me on account of cancellation of registration of my supplier. That is one issue which is covered by the judgment of this Honorable High Court, and now there is a Supreme Court judgment also, even though in the context of VAT law, but that judgment is there that merely because the registration of my supplier has been cancelled, ITC cannot be denied. And
that was the only ground.
That was the only ground.
No collusion, genuine.
No, there is no such allegation. With respect to, my lord, there are few supplier. With respect to that allegation is there that these are non-existent supplier and all that. With respect to those supplier, they have already paid the tax amount. The day one when the inquiry was done, they paid the tax amount. With respect to those supplier, where there were other allegation also, with respect to say they are non-existent at their place of business and all that, those taxes have been paid. But the third category of demand is, my lord, that ITC has been denied to me solely on the ground that there is a mismatch between GSTR 2A and 3B. My lord, 3B is the final return. 2A is auto-populated when, my lord, my supplier files GSTR 1. That is invoice-wise detail of all the suppliers. I have 10 different suppliers. All of them will file their sales return, invoice-wise detail, where the invoice number, the TIN number, and all those details are there. And once my supplier files, then, my lord, at my end, it gets auto-populated in GSTR 2A. There is a form GSTR 2A, which just reflects in the GSTN portal only. So I have no control over that GSTR 2A. GSTR 3B is the return which I file, whereas whatever input tax credit is admissible to me, I claim on the basis of the invoices available with me. Suppose there may be an error on part of some supplier, they inadvertently, my lord, writes my TIN number, whereas I have not purchased those goods. So I will not claim that ITC just because it pops up in GSTR 2A. Similarly, there may be some blocked credit also, which I am not entitled to. So I will not take that credit also. So I don't take credit solely on the basis of 2A. And, my lord, there is also import of goods. So with respect to import of goods, there is no supplier. Once I import the goods, then I claim credit on the basis of bill of entries, which I file with the customs department. On the import of the goods, there is no supplier who is going to file that GSTR 1 return. So there is no question of auto-population of that data of the import of goods in GSTR 2A, because I am myself importing the goods and I am myself making the payment of the IGST also. And on the basis of that document, which is bill of entry, I am claiming the credit. So with respect to the import of the goods, initially in the so-called notice, just the allegation was made that your 2A is 3B is more than 2A. At the stage of GSTR 1A, I clarified that this is with respect to import of the goods, so it is not going to get auto-populated in the 2A. And rule also says so. Rule 36 says very clearly that with respect to import of the goods, there is no need for auto-population of the data in 2A. And there is a circular also, which says that with respect to import of the goods, this auto-population will not happen because there is no supplier at my lord, but my lord, at the order level, my lord, the authority says that you have not submitted bill of lading. I have received those bill of entries and all that, whichever documents I submitted to substantiate my veracity of the import of the goods. He says that the bill of lading is not there, and therefore there is no proof that you have received the goods. Now, my lord, number one, the bill of lading was never demanded from me at the SOCOG stage, neither at the pre-SOCOG.
But why should the court interfere at the 226 in a
Well,
226 jurisdiction at the order in original stage? Why not appeal?
No, my lord, I'm clarifying, my lord, there is a issue of the determination of the jurisdictional fact. The jurisdictional fact is whether this demand can be raised on the basis of 2A or 3B or without verification as to whether this is pertaining to import of the goods or whether it is pertaining to.
Can this issue be decided by the writ court without making any factual inquiry?
My lord,
Because
there is no, my lord, factual. There is no factual dispute. Now, my lord, this is this pure question of law, whether with respect to import of the goods, this demand can be raised on the basis of difference between 2A and 3B. So that is the sole question of that. They are not disputing with respect to, my lord, the that I am, my lord, this is not import of the goods.
The mismatch would have been because of what reasons?
Because, my lord, there is no supplier.
For whatever reason, if there is a mismatch, will that not give them jurisdiction to slash off your ITC?
No, my lord, there are three stages. One is the pre-SOCOG stage. It is sort of, my lord,
that is the stage. We are not in that at all. We are on the assumption of jurisdiction. If
Yes.
there is a mismatch, am I or am I not entitled, being a GST authority, to ask you to explain why there is a mismatch and why you should not be allowed to avail ITC?
So he asked me at GSTR 1A. I responded to that. And he should have considered my reply. There is a judgment of this honorable division bench itself that once I furnish my reply in response to GSTR 1A, which is prior to the SOCOG stage, because that is a stage, sort of a mediation stage, where if suppose there is a doubt.
But then that will be passed only when you come at that stage. You do not come to the writ court at that stage.
No, I did not come at the GSTR 1A stage.
So that is what I'm saying. If you want that, that exercise should have been completed, the court intervened in that case only because the assessee had come at that stage. The taxpayer
No. The SSC came at the order stage, my lord, because they did not consider the reply at GSTR 1A stage. Now, I filed my reply at GSTR 1A stage. I filed my reply at the GSTR 1 stage also. Now they at the GSTR 1, suppose they are now, because they are changing stand at GSTR 1A stage as well as 1 stage, the only point of contention was the difference between GSTR 2A and 3B, which I duly explained at both the stages. Now, as per section 75 subsection 4, he cannot, my lord, pass order going beyond the allegation specified in the SOCOG notice. He cannot raise a new ground in the order. So, in the order stage, now he is saying that you have not furnished bill of lading. Had he demanded at the stage of, suppose GSTR 1A, he was blank. He was not aware. He just looked at my GSTR 2A, 3B data. He has a doubt. So, he is very much entitled to ask me about the difference arising. I explained him. Thereafter, at the GSTR 1 stage, when I have given a detailed reply to him, if he had any doubt about the receipt of the goods at my end or the bill of lading being the necessary document according to him, which it is not, I will show, my lord, from Rule 36 that the only document which is necessary for claiming goods with respect to import of the goods is bill of lading. My lord, kindly have a look at, my lord, Rule 36, my lord.
Rule 36.
Rule 36, my lord. It talks about the documentary requirements and condition for claiming input tax credit. The input tax credit shall be availed by a registered person, including the input service distributor, on the basis of any of the following documents, namely, an invoice issued by the supplier of the goods, an invoice in accordance with the provision of clause F of subsection 3 of 31, a debit note. Number D is important for me. A bill of entry or any similar document prescribed under the Customs Act 62 or rules made thereunder for the assessment of integrated tax on import. So this is the only document which is valid for claiming ITC on the import of the goods, because I myself pay this tax. And that is not disputing that I have furnished bill of entries to him.
No, it may not be so. This is there for the purpose of availment. Now, if a question is raised on any of the on the genuineness of the transaction or on the modus operandi of the transaction, then you may have to furnish more documents. Maybe this
So
document
that
will not suffice.
Suppose if it demands,
it depends on the case. It is
Correct.
not that in all cases, if you show these 4 documents, the authorities will have to be satisfied by these 4
That is
and they will not
no,
ask
that is not the case. But import is a case, my lord, where I am myself paying the tax. But suppose there is a supplier. It may be a case, there is a case of
take me through the I'll come back in 5 minutes.
Lord, my learned friend is arguing on the merit of the matter.
May I
whether
complete, my lord?
there is any, this is an error within the jurisdiction, even if for the sake of
You
argument.
take me through the papers. Pre-show cause where that is.
He did not produce any document even pre-Shuko stage, even in the inquiry stage, in the ordinary original past, my lord.
But kindly refer to, my lord, DRC 01A, my lord.
Page.
Just pointing out, my lord.
106, your lord.
Page 106, my lord.
106.
106.
106, yes.
106, my lord. Just reading out. It has been unearthed during the course of investigation that so and so has availed and utilized ineligible ITC to the tune of 87, 26, 900. Table A 41, 39, 304. Table B 45, 87, 596 during the period from 17 to 23 on the basis of fake bogus invoices issued by the entities as chartered underneath after cancellation of GST registration. Table A cancelled suo moto. So these are the dealers under the table A where they have initiated the proceeding only on the basis of cancellation of the dealer's registration. Table B, non-existent supplier. There is a list, my lord. Further, on scrutiny of 2A, 2B, 3B and 9 for the period of 17 to 23, it is found that as per the calculation as annexed in Annexure C, the said RTP has availed access ITC to the tune of 4 crore 75, 74 in their 3B 9 returns. The detail of differential amount are furnished under. Now, kindly see then my next paragraph. However, during the course of investigation, Mr. Silverton has accepted the ineligibility of ITC total amounting to be 21,17,498 out of the total detected ineligible ITC of so and so due to fake bogus supplies as per table B. Table B is, my lord, non-existent supplier, which was received from so and so party's name are also, my lord, there, which are furnished below. Since the Silverton has availed and utilized fraudulent ITC to the tune of so and so from supplier as mentioned in table A and B above after the effective date of cancellation of the registration of the said suppliers, the said RTP has also availed access ITC to the tune of 475, 74, 569, which are not reversed, thereby violating the provision of section 16(2), read with 7, and further read with rule 36 of the CGST rules. Mr. Silverton shall be liable for demand and recovery of the said ITC under section 74(1) of the Act. But this is also a point of contention for us that they could not have invoked 74. I will come to that later on, my lord. Is impossible upon the SEC for the conduct of fraudulent activity. Since Silverton has availed ITC from cancelled and non-existent supplier amounting to rupees 6609 and availed ITC to the tune of 475.74 in their annual return in GSTR 9(3)B without reversal of the same as mentioned in table ABC respectively, it is requested to so and so. Now, my lord, kindly refer to my reply, page 110, madam. But kindly see page 11.
Where is the show cause notice?
But I am coming to that, my lord. I am in,
No, let me see once.
show cause notice, my lord, is on page 117. My lord, the detailed show cause notice starts from 122. Kindly refer to page 125, my lord.
Have they not referred to your reply?
But kindly refer to page 128, where they are just referring to the payment made. Paragraph 4, my lord. That is all, my lord.
No,
They have just reproduced GSTR 1A, my lord,
They
in 1.
have not submitted the reply.
My lord, a reply is there, my lord, page
What is the
110
date of
onwards.
the show cause notice? This is 30th of July 2024. And what is the date of your? You have submitted the reply after issuance of show cause notice.
No, my lord. The show cause notice is dated 1st of August 24.
No, sir. Detailed notice you see page 122.
No, no, my lord, but it is uploaded on the portal after
Very
considering.
well, on 31st of July, if you file the reply,
Yes,
then
my
how
lord.
will they consider it?
My lord,
By that time, the show cause notice, this detailed show cause notice was prepared.
my lord, the show cause notice is issued only on 4/7/24.
Very well.
And
Your reply at page 1110 goes on 31st of July 2024.
Correct.
By the time when the reply goes at page 122, the detailed show cause notice is ready. It is 30th of June, July 2024. So there was no occasion for them to consider it.
But they have uploaded it on first.
They may have uploaded it. Once they have made it ready, it is their obligation to reach it even after you give it late, because they had indicated the time within which you are supposed
Under
to
section 75, kindly refer to section 75 for once. Section 75. But kindly see subsection 4.
Just a minute. Just a minute. I'll see. Which page is DRC 01?
Well, DRC 01 is starting from 117. 117 is the form, DRC 01.
And where is the pre-show cause?
Pre-show cause is, my lord, page 106.
They're given you 15 days time.
Yes, 15 days time.
Reply. Yes. What is the problem?
He gave
Well,
submit on 31st July.
Yes. And they have,
My lord, there is no, my lord, they have given me time, but my lord,
Yes.
I am just trying to show, my lord,
But then that judgment of division bench will not come to your rescue.
No, my lord, what I am saying, my lord, that they need to also give me an opportunity of hearing if they are contemplating
For
any.
the purpose of issuance of show cause notice, opportunity of hearing is not required.
No, my lord, in section 75 also.
70. This is 30th.
That they can also, my lord, it is a reasonable period, my lord. My lord, 4th of July.
15 days is quite reasonable for
No, my lord, considering, my lord, the three disputes were involved. And my lord, I just want to show, my lord, that the day, my lord, they came to my premises, my lord.
Very well. And what is wrong with the order in original? Now you tell me.
My lord, I will show, my lord. Kindly refer to. I'll just first take your lordship to this import issue, my lord. Kindly first, my lord.
Please show me the jurisdictional issue, because writ court, as a writ court, I will not go into factual disputes. It's not my domain. Then appellate authority will become useless. All the disputes will come to the writ court. Appellate authority will become. It has to be then washed off from the statute.
No,
It has to be there to be functional. It cannot be made fatuous. Only the writ court will keep on entertaining writ petitions even against order in original. Appellate authority will have no business to do. Then we'll have to wrap it up.
What I am submitting, I'll just no, my lord, correct, my lord. I will just show, my lord, one judgment that before assuming jurisdiction, my lord, they have to correctly determine the jurisdictional fact before they cannot.
That's settled.
They cannot incorrectly.
Two facts are there. There has to be jurisdictional fact. Once the jurisdictional facts are set right, then we go into adjudicatory facts.
Correct.
Now, before going into adjudicatory facts, we have to see that you have decided the jurisdictional fact rightly. If an authority assumes wrong jurisdiction, decides jurisdictional facts wrongly, that is an error of jurisdiction which can be corrected by the writ court. This is settled. No dispute at all. But here in this case, at the stage of issuance of so-called notice, this does not appear to be an error of jurisdiction of such magnitude that cannot be corrected by the appellate authority, and that it has to be intervened at the order in original state stage by the writ court
My
in
lord,
226.
my lord, the jurisdictional fact is this, my lord, that before assuming jurisdiction, he needed to correctly determine that whether the demand can be raised on the basis of 2A and 3B, difference between 2A and 3B with
There are
respect.
3-4 issues. In respect
One-
of one of the issues, did it in respect of all the issues has it
No,
been
no,
done?
second issue also, my lord, there is an error of jurisdiction. I will show the Supreme Court judgment that there are binding precedent. There are so many judgments of this Honorable High Court that merely because there is a cancellation of registration of the supplier, my lord, they cannot raise demand solely on that basis. Had he conducted any investigation, my lord,
It is not solely on that basis. There are 3 cases, 3 or 4
three cases, my lord. So with respect to one category, my lord, where they are alleging non-existence, I have already paid the tax.
There is fraudulent availment of ITC.
So-
This is one.
That is
Then-
B. My lord, that is table B.
Then unutilized excess availment of ITC is there.
No, my lord, there are 3 issues. My lord, they are very, my lord, categorized under 3 category. One is suo motu cancellation of registration of the supplier.
Yes.
Second is non-existent supplier.
Yes.
3 is this 2A versus 3B issue. There are 3 issues. With respect to non-existent supplier, they have already paid the tax. With respect to suo motu cancellation of the registration of the supplier, they needed to do further investigation. There is also judgment of this Honorable High Court that they first need to approach the supplier first. That also judgment they need to, they should have followed. That is a binding precedent, my lord. I will show, my lord, that there is a judgment of the Supreme Court that the authority cannot issue so-called notice ignoring the binding precedent of the concerned High Court, my lord.
That's settled. That's settled.
So they have not considered those judgments, my lord. We have also cited in our GSTR 2 1A reply, GSTR 1 reply also that these are the binding precedent. Had they conducted any further investigation that my say invoices are fake, there is no movement of the goods, I have not received the goods, had they conducted any such investigation and then issued so-called notice or order, my lord, that was, my lord, acceptable. Then I would have to approach the, my lord, the appellate authority. But that exercise they have not done. At 1A, both stage, my lord, they have just reproduced. Even in the order, my lord, they have reproduced their 1A.
Because one way they one A they had to reproduce because there was nothing forthcoming from your side to the pre-show cause notice. Whatever came from the pre-show cause, if something had something material had come from you at the in answer to the pre-show cause notice, they might have changed their opinion. They might have added to their view. They might have deviated from the view originally taken. But there has to be some material for them to change it. There was no material, so they had to copy paste whatever they had said earlier, and that is what they have done. Now, in answer
At
to
the
show cause
order
notice,
stage,
in answer to the show cause notice, now whatever you say, that has to be factored in the order in original, and if that has been answered in one way or the other, can you say from the order in original? Can you show that?
Well, that is what I'm showing, my lord. My lord, kindly refer to sections, my lord, section 75, subsection 7.
Section 75,
Subsection 7.
Yes.
The amount of tax, interest, I'll just read out, my lord.
Section 75,
Seven.
subsection 7. Yes.
The amount of tax, interest, and penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be confirmed on the grounds other than ground specified in the notice. So both these conditions have to be satisfied for passing of the order. My lord, I'll just show how they have considered my reply. Now I am ignoring, my lord, 1A stage at the for the time being. My lord, kindly consider my reply in response to their my lord, before passing the final order, my lord.
Yes.
My lord, this the major demand, my lord, which is with respect to the, my lord, the import. My lord, kindly consider, my lord, my reply.
Page.
In response to the so-called notice, my lord. Page 139, my lord.
Page 139.
Yes, my lord.
Yes.
139, my lord. Kindly just, my lord, I'll just take your lordship to the part with respect to that 2A and 3B, my lord. Kindly consider B.
B.
Yes. In respect of point number 2 as per notice, we would like to inform your good sir that the eligibility for claiming input tax credit as per section 62AA of the Central Goods and Service Tax pertains specifically to invoices. However, in this case, registered taxpayer has claimed input tax credit in respect of import of the goods on the date on which we received the material in our warehouse. We take input tax credit of imported goods on the basis of bill of entry provided by the customs department only when the goods reach our warehouse in accordance with rule 36(1)(d) of the CGST rules. The excess ITC claim, the difference between 2A and 3B amounting to rupees 4,58,52,707 as per 1A is the difference of ITC claimed on the basis of bill of entry as per rule 36(1)(d) of the CGST Act. We are also attaching reconciliation for the period 17 to 23 and copies of bill of entry for your reference as an attachment. Now, let kindly see how he considers my reply. Kindly refer to page 120. Page 76, man.
Page 76.
1 second. You may kindly refer to 74 first, paragraph 13.9.
74.
Paragraph 13.9. Now I am coming to the discussion. Shall I read out?
Yes, I am.
Now I am coming to the discussion on the excess availment of ITC in GSTR 3B versus 9 over and above eligible ITC available in 2A, 2B, violating the provision of 16(2) of the CGST WBGST Act. It has been alleged in the impugned SCN that the noticee so and so had availed and utilized excess ITC to the tune of 4 crore 75 only as availed in 3B 9 and over eligible ITC available in 2A, 2B, violating the provision of 16(2) of the CGST Act, which stipulates certain criteria to be fulfilled for claiming input tax credit. For claiming ITC, a registered person shall be in possession of a tax invoice or debit note issued by the supplier registered under this Act, or the taxpayer has received the goods or services or both, or such other taxpaying document as may be prescribed. Details of such invoice, debit note are furnished by their supplier in GSTR 1, subject to provision of. Now, my lord, kindly turn over to 76. This 75, my lord, it is a my lord, it was page 73. It, my lord, again inadvertently got included. So, 74 continuation is page 76, my lord. Subject to provision of section 41. The tax charged in respect of such supply has been actually paid to the government either in cash or through utilization of input tax credit admissible in respect of said supply etc. In present case, it is alleged that the noticee have claimed availed excess ITC to the tune of 475,74,569 only without receipt of underlying goods or services or both during the financial year as detailed herein below. There was no such allegation that I have not received the goods. And when I have myself imported the goods, do I throw it in elsewhere? How? Why should I not receive the goods which I have myself imported and paid the customs duty? Then, my lord, for ITC availed by the noticee for financial year 17-18 to 2021, figures declared in 3B has been taken into consideration, and for financial year 21-22 to 22-23, figures declared in 9 has been taken into consideration. For financial year so and so, ITC available as per 2A, 2B is more than availed in 9. Hence, there is no allegation for excess availment in the instant SCN. In this regard, the noticee submitted that they have claimed ITC in respect of import of goods on the date on which they receive the material in their warehouse. They take input tax credit of imported goods on the basis of bill of entry provided by the customs department only when the goods reach at our warehouse in accordance with rule 35(1)(d) of the CGST rules. The excess ITC claim, the difference between 2A and 3B amounting to rupees so and so, is the difference of ITC claimed on the basis of bill of entry as per 36(1)(d) of the CGST. As the noticee did not contain any other issue of ITC other than bill of entry, it can be presumed that the ITC availed by noticee has been correctly determined by the so-called notice issuing authority. Hence, I am restricting myself on the discussion of ITC availed by the noticee on the strength of bill of entry. Now, as the eligibility of taking ITC is governed by 16 of the CGST, I would like to highlight the same to decide the issue. Now, section 16 is reproduced. 2A, he is in possession of the tax invoice or debit note so and so, he has received the goods. Then, my lord, other conditions are stated. In the instant case, the noticee have submitted only bill of entries in support of their claim. However, the noticee failed to submit the corresponding bill of lading. The bill of lading is a document issued by the carrier or its agent to the shipper of the goods as a contract of carriage of goods. It is also a receipt for cargo accepted for transportation. It must be presented for taking delivery of the goods at the destination. The bill of lading serves as a proof of ownership or title of the cargo. Hence, in the absence of substantive document, I find that it could not be established that the goods have been actually received by the noticee. Accordingly, I am of the opinion that the condition laid out in 16(2)(b) has not been fulfilled in the instant case. So the case started with violation of Rule 36(4) that there is a difference between 2A and 3B. There was no other allegation. I have submitted my bill of entries, which also is not disputing. Now he is saying that you have not furnished bill of lading. Now, bill of lading, my lord, is a document, my lord, which is necessary for filing bill of entry. I cannot file bill of entry and pay the IGST or the customs duty without receiving the goods. The customs department will not allow clearance of the goods unless I furnish bill of lading, which he himself is stating. Had he demanded, my lord, even in the course of hearing, had he stated that you have furnished bill of entry, because there is a necessity of bill of entry hearing also, my lord, which has to be given by the officer. So if he has any doubt in his mind with respect to, my lord, this bill of lading issue, he could have very well told me that you furnish this bill of lading, I will consider. He did not say that in the course of hearing also. But he comes to the conclusion that I have not received the goods because I have not furnished bill of lading. My lord, my own imported goods, how do I not receive the goods, my lord? It is not a my lord, supply from a third party. But they can also verify this bill of entries from the customs department. It is all part of the within the Ministry of Finance Central.
What is the show cause notice on this point? Show me that.
But show cause notice, my lord, is on page 170. The relevant paragraph is on page 127. 127, my lord. Paragraph 2.8, my lord. 2.8. I'm reading out, my lord.
No, okay. No, but this issue of whether you have received the goods or not was very much there. Without receipt of underlying goods or services.
My lord,
So
without
this issue was there.
my lord, I have furnished. I have stated that I have received this in
So
my warehouse.
it is a question. It is a question of the sufficiency of the documents to satisfy. You cannot say that this question.
But bill of lading.
The question that whether you had received the goods or not was never involved cannot be said. This question was very much involved.
My lord, kindly.
How you are going to answer this is definitely an issue.
Kindly appreciate, my lord. It would be an absurdity to say that I have not received the. Primarily, he has a doubt that there is a difference between 2A and 3B. Probably I have received it from the third party. So, my lord, I have, my lord, there is a question of doubt of the receipt of the goods also. My lord, I don't doubt his, my lord, the questioning that I have not received the goods. Provided, my lord, it was a normal case where I am receiving it from the third party. Then, my lord, that doubt can always be expressed, my lord. But this is a case where I have myself, my lord, purchased the goods. It is not a, my lord, purchase from the third party where there can be any question of the receipt of the goods. If he doubted my bill of entries, my lord, it is, my lord, the CGST department and customs department. They are part of the same, my lord, Ministry of Finance, part of the same Central Board of Indirect Taxes. So they can very well verify this, whether these goods have been has landed in the country, whether the goods have been delivered to the supplier.
You say that production of bill of entry itself is proof of you having received the goods.
Bill of entry itself is a proof, my lord. With respect to imported goods, my lord, other transactions, my lord, they can always doubt the receipt of the goods and all that. But with respect to import of the goods, It would be an absurdity to say, my lord, they can raise any question, my lord, but the question is, my lord, it has to be reasonable question, which a common man can understand, my lord, without forget about the law point of
Mr.
it.
Bhattacharya, if he has produced the bill of entry,
Well, bill of
still how can you say that he has not produced the goods? He has not received the goods.
well, only bill of entry is not sufficient, my lord. So
Why?
because, my lord, as per section 36(4), if your lord sees, well,
Yes.
the tax invoice and debit notes has to be produced by.
So, my lord, I will show, my lord.
The authority says you have not produced the bill of lading.
No.
I'll just show, my lord, I will complete that. Just, my lord, answer him. This one circular I will show with respect to import of the goods, my lord. Just, it will take 1 minute only. But paragraph 3 I will read out. It will take 1 minute only. The conditions and eligibility for the ITC that may availed by the recipient shall continue to be governed as per the provision of so and so and the rules made there. This being a new provision, the restriction is not imposed through the common portal. It is the responsibility of the taxpayer that the credit is availed in terms of said rule. And therefore, availment of restricted credit in terms of sub rule 4 of 36 shall be done on self-assessment basis by the taxpayer. Various issues. Now, issue number 1. What are the invoices, debit notes on which the restriction under Rule 36(4) of the CGST rule apply? Rule 36(4) is with respect to, my lord, this 2A and 2B. That unless it appears there, I cannot claim the credit. It is answered like this. The restriction of availment of ITC is imposed only in respect of those invoices, debit notes, details of which are required to be uploaded by the supplier under subsection 1 of section 37 and which has not been uploaded. Therefore, taxpayer may avail full ITC in respect of IGST paid on imports, documents issued under RCM. RCM means on my own, which I am receiving, and I am myself paying the tax. Credit received from ISD, etc., which are outside the ambit of subsection 1 of 37, provided that the eligible condition for availment of ITC are met in respect of the term. The restriction of 36(4) will be applicable only on invoices, debit notes on which credit is available. That is another issue, but it very clearly says that ITC with respect to import, that the condition of Rule 36(4) does not apply, my lord. That 2A and 3B difference. So before assuming jurisdiction, but that much he needs to verify, my lord. And also, my lord, I refer to one Madras High Court judgment directly covering this issue, my lord, where the order has been set aside. Very, my lord, one-page judgment. Well, paragraph 2 onwards, I am reading out. The petitioner is before this court against the impugned order dated so and so passed by the respondent imposing the tax due from the petitioner on account of different in return filed by the petitioner in GSTR 3B and auto-populated input tax credit in 2A. The case of the petitioner is that the petitioner had imported timber from overseas customer and paid the IGST at the time of import. It is submitted that the supplier is not in the country and not a GST registered concern. There is no possibility for the form 2A being generated on the tax by the petitioner under IGST. It is submitted that the petitioner, however, failed to respond to the notice and so and the so-called in so and so. He did not even reply to the so-called notice, this particular petitioner. It is submitted the petitioner also failed to respond to personal hearing. Now, my lord, that apart, the learned counsel for the petitioner submit that the sum of so and so has been recovered by the respondent towards him. Having considered the submission made by the learned counsel for the petitioner and the learned government advocate for the respondent, and considering the facts that there is no scope for auto-population of the input tax credit on IGST, the court is inclined to come to rescue the petitioner by quashing the impugned order and remitting the case back to the respondent to pass press order. The impugned order which stand quashed shall be treated as an addendum to so-called notice in GSTR 1. The petitioner shall reply. Same issue, my lord. And with respect to, my lord, the other issue also, my lord, if your lordship permits, the cancellation of the registration, my lord.
So in case of import, GSTR 2A will obviously not be generated in case of the exporter, because the exporter is outside
the country. So, my lord, the entire, my lord, the basis of assuming jurisdiction was that there is a difference in 2A and 3B. And they also themselves can verify, my lord, on the portal itself, because all these data are auto-populated. The customs department also transmit the data internally to them.
Yes.
Because
next one.
But with respect to, my lord, the cancellation of the registration, my lord, I'll refer to this very recent Supreme Court judgment, my lord.
Yes, I have seen this.
Paragraph 2, my lord. In these appeals, the short issue that arose for consideration before the Delhi High Court whether the benefit of input tax credit is available to the registered purchase dealers who pay taxes to the registered seller in terms of the invoices raised by them, even though those sellers, the dealer did not deposit the collection tax with the government. There is no dispute that on the date of transaction, the seller dealer were registered with the department. However, after the transaction, the registration of those seller dealer were cancelled and they defaulted in depositing the tax collected by them from the purchaser dealer. The High Court wide impugned judgment and order found respondent bona fide purchase dealer who had paid taxes in good faith to the registered seller and therefore entitled to benefit of ITC and accordingly allowed the said benefit to them after due verification of invoices. A similar issue later arose for consideration before the High Court in on quest so and so, reported in so and so in the context of the provision of Section 9(2) of the Delhi Value Added Tax Act. Section 9 of the DV Act permits ITC to a registered dealer in respect of turnover of purchases occurring during the tax period where the purchase arises in the course of his activities as a dealer and the goods are to be used by him directly or indirectly for the purpose of making sales which are liable to tax under section so and so. Subsection 2 of 9 sets out the conditions under which the ITC would not be allowed. Clause G of subsection 2 of section 9 made ITC benefit available to a purchasing dealer only when the tax paid by the purchasing dealer has actually been deposited by the selling dealer with the government.
Mr. Saraf.
Kindly, I'll just refer to a few more judgment, of this Honorable High Court on this particular issue, the cancellation of the dealer, and there is also, only one page Supreme Court judgment. But kindly refer to page 5, page 3, paragraph 5, page 3. In our view, the High Court was right. A purchasing dealer is entitled by law to rely upon the certificate of registration of the selling dealer and to act upon it. Whatever may be the effect of a retrospective cancellation of the selling dealer, it can have no effect upon any person who has acted upon the strength of a registration certificate when the registration was current. The argument on behalf of the department that it was the duty of the person dealing with the registered dealer to find out whether the state of fact exists which would justify the cancellation of the registration must be rejected. To accept it would be to nullify the provision of the statute which entitle person dealing with registered dealer to act upon the strength of the registration certificate. Now, I will kindly refer to there are number of judgments which I have included, but I will refer to only one, page 26, my lord. Page 24 onwards, my lord, the judgment is there. Paragraph 12. The main contention of the petitioner that the transaction in question are genuine and valid and relying upon all the supporting relevant documents required under the law, petitioner with due diligence verified the genuineness and identity of the supplier and the name of supplier as registered taxation person was available at the government portal showing its registration as valid and existing at the time of transaction. Admittedly, at the time of transaction, the name of supplier as registered taxable person was already available with the government record, and petitioner has paid the amount of purchased article as well as the tax, the same through bank and not in case. It is not the case of the respondent that there is a collusion between petitioner and supplier with regard to the transaction. These courts find that without proper verification, it cannot be said that there was any failure on part of the petitioner in compliance of the any obligation required under the statute before entering into transaction. The respondent authority is only taking into the consideration of the cancellation of the registration of the supplier with retrospective effect. But then one judgment.
Same points I have seen only on the ground.
One judgment that they first must approach the supplier. The judgment of the Honorable Division Bench, page 21. Page 21, it starts at page 18, my lord. The relevant paragraph is 21.
Yes, I have.
Paragraph 9.
I have seen this.
Yes, my lord. Then, my lord, one judgment with respect to, my lord, that your lordship is already aware, but just, my lord, for the record, my lord. Page 27. Sorry. Page 4 onwards, there is this judgment. Page 11, my lord. Kindly page 12, my lord, last part of it. I'm just reading out. We therefore hold that the law declared by the highest court in the state is binding on the authorities or
Page 12 is a notification.
They cannot ignore it either in initiating a proceeding or deciding on the rights involved in a proceeding. If that be so, the notice issued by the authority signifying the launch of proceeding contrary to law laid down by the High Court would be invalid and the proceeding themselves would be without jurisdiction.
Page 12 I don't have. Page 12 is something else.
But of this compilation.
Yes.
No, separately. So this is, you kindly take it. Maybe there is some error in the pagination, my lord. I don't. Page 9, my lord, kindly refer to just above paragraph 30. Paragraph 30, last sentence.
If that be so.
We therefore hold that the law declared by the highest is.
Got it. Very well.
Then, my lord, there is also issue of the extended period of limitation, my lord. Kindly have a look at how they have extended the period of limitation, my lord, in the so-called notice. My lord, kindly refer to page 134, my lord.
134.
Paragraph 8.
Paragraph
8.
F.
8.
Invocation of extended.
Investigation in this case was started with the intelligence that Silverton had availed irregular ITC on the basis of invoices purported to be issued by the said non-existent entity against whom alleged circular has been issued by the Kolkata South and Kolkata North Commissionerate. It is thus evident from the finding of the investigation that Silverton Metal Private Limited have engaged in fraudulent activity and willful misstatement and availed irregular ITC deliberately with the intent to evade taxes. Had this department not investigated into the case, Messrs. Silverton would have continued to avail such irregular ITC and utilize the same towards payment of taxes against outward supply. Accordingly, the provision of 74.
Yes, I read it.
So
Yes,
they have invoked 74 only with respect to those fake supply. With respect to this particular 2A and 3B, according to their own so-called notice, there is no cause of action for invocation of extended period. And in my case, my lord, since the demand is from 1718 to 2223, so for 1718, 1819 and 1920, it is already barred by limitation. They have not made out any case as per their own notice for invocation of extended period with respect to, my lord, this 2A and 3B issue. Only with respect to non-existent, they have invoked that. Even with respect to cancelled supplier, my lord, they have not invoked that 74.
Yes, Mr. Bhattacharya. Limitation is also an issue now. Because extended period of limitation, you have only invoked for the purpose of this this portion where you have found or you have alleged that there has been irregular availment of ITC from fake suppliers. So far as mismatch and all these things are concerned, those will be barred by limitation then.
But in fact, though there was no specific language used.
So you
it
have
is also my irregular availment of my lord ITC there.
No.
Where he
irregular availment of ITC is different from willful
Mismatch of the-
misstatement, suppression, fraud. These are strong things. Those will come under 73. If
Yes.
it is under 73, then in that case it's 3 years. You have extended the period, availed it for 5 years, extended it to 5 years.
74.
74. So why this?
My lord, in this case, my lord, though specifically it has not been, but paragraph 8 is not there. But my lord, so lord, my lord,
No, it's your specific case. That is the case.
Yes.
If that is the case of the department, then in that case, how do you proceed?
In fact, on that, there is a Supreme Court judgment, if your lordship permits me, that there has to be a specific amendment, my lord, for invocation of the
text on
extended
page 127, 4.8, if your lordship will sees. The so cause it has been specified.
Kindly
there.
refer to page 20, my lord. Page 20, paragraph 25. Paragraph 25. Moreover, this code, shall I read this code through?
You don't need to please.
Then, my lord, there are two judgments of this Honorable High Court where court says that if it is on the basis of my own record, then also extended period cannot be invoked. My lord, my lord, I will refer to page 28, my lord. The judgment starts, the division bench judgment, my lord. Judgment starts at page 23. Page 28, my lord. Page 28.
This is matter relating to Customs Act, my lord, section 28.
No, he's on limitation of.
Yes, my lord, he is placing.
Whether it is
25.
Customs Act, my lord, similarly worded provisions are there. Even
The application of the principle.
My lord, whether
Well,
I don't know the facts of the case, I have
the
to
act to
verify.
complete according to this.
Of course, principle
Otherwise,
will
it
be
is very
applicable.
difficult. My lord, I will have to answer.
My lord,
to
page
this.
28, my lord.
You don't need to answer today.
No, yes,
In
my
any case, we cannot continue with hearing matters at the
Correct,
motion
correct,
stage.
correct.
Well, page
My lord,
28, my lord.
Had it been a case, my lord,
Mr. Bhattacharya, when you are well prepared, then only start. Don't
no,
halfway
why I am
halfway down the argument. Please don't say that I'll come back. If you want to come back, tell it now so that you can come back prepared.
My lord, my learned friend is right from, he is arguing as an appeal.
No,
to
no,
the writ court.
I have not, I mean, not permitted him to argue as an appeal. I have
He placed
restricted.
all material pure lordsman.
No, not at all. I have only restricted him to argue jurisdictional issues, and that is what he has argued.
But kindly refer to page 28, my lord. Page 28, second sentence onwards, my lord. Furthermore, all the details were reflected in their books of accounts and balance sheet, and also where all the facts and figures have been explicitly brought on record, and therefore the question of suppression of fact would not arise. Thus, the specific submission of the SSE could not be shown to be wrong by the department before the tribunal. The tribunal has rightly held that the extended period of limitation cannot be invoked. But then one more judgment, my lord.
Yes, Mr. Bhattacharya, when do you want to come? Give me a date so that we can move on. Take full instructions because he has raised a lot of points.
My lord. My lord, keep it 15, my lord.
15, my lord, my lord, I have a matter in
Next
other.
16.
Because it will be convenient for grateful.
Again, Mr. Sarab will bring other judgment.
No, same. I will not bring other judgment.
And then will give us a compilation idea.
Didi call for.
Grateful.
Here will address.
Yes. I was about to tell. Good. But Mr. Bhonjo will lead you. Yes, sir.
Weak team, I am afraid. So many stalwarts in the revenue side. I am single. So
And we were thinking that this matter comes up after lunch. Last week, take us for lunch.
It won't be longer than 8 minutes.
my matter is also very short. The SEC is under the control of State Tax Authority. An investigation was conducted by the state tax authorities and they have issued a show cause notice. Adjudication order was passed for the period 2017-18 and 2018-19. Subsequently, central authorities also started inquiry and made investigation. Same period, same issue. And at that stage, I informed that already State Tax Authority had conducted investigation and this much. In the meantime, they have issued the Central Tax Authority issued a show cause notice. That show cause notice, I have challenged this court and they are the direction of this court, Justice Nizamuddin, to exchange the affidavits. Affidavit complete. And that was supposed to come hearing. At this stage, they asked for hearing. The representative appeared and explained that show cause notice under challenge and the affidavit exchange, so kindly not to take any steps. And the matter was mentioned by as the Honorable Court time did not permit, matter was not taken up. In the meantime, that adjudication order passed. Now, again, I have filed a fresh petition against the adjudication order. Now, first, today, I am challenging the adjudication order on the ground that there is a parallel proceedings cannot be continued under Section 6. And thereafter, the Supreme Court judgment recently, before last week it came, clarified all these issues. Before going to that, if I want to take a trouble to your lordship to go through this Section 6 for a moment. CGST Act Section 6.
Yes.
Lordship got it, 6. This is a chapter is administration. Just I'm touching before that. Section 3 is officers under this act, under Central Tax Act, CGST Act. Not need. Section 4 is appointment. That is not necessary. This is appointment on the CGST officers. Section 5 is the powers of the officers of CGST Act. So 3, 4, and 5 only for the appointment of the CGST Act officers. Now, crucial is that Section 6. That is important. That is today's case. Authorization of officers of state tax or union territory tax as proper officer in certain circumstances. Subsection 1. Without prejudice to the provisions of this Act, the officers appointed under the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act are authorized to be the proper officer for the purpose of this Act, subject to such conditions as the government shall, on the recommendation of the Council, by notification specify. This is a general. I am not going. It is not strictly. There is so many issues. I am not going to that. Subsection 2. Subject to the conditions specified in the notification issued under subsection 1A, where any proper officer issues an order under this Act, he shall also issue an order under this State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act as authorized by the State Goods Tax Officer Act or the Union Territory Goods and Service Tax Act,
What
as the
point
case
is that,
may be.
Mr. Das, that they have not been authorized.
No, my lord. That is in the writ petition, I have taken this point, honestly speaking. That is one of my points. But today, I am going one step further regarding when the Supreme Court has come. My case is more strong. That is the reason.
Let us come to that.
I'm coming. Kindly read.
Section I've seen.
Your lordship, as our subsection clause B also. My B is my case. B is saying when the state tax officer interfered, central tax cannot come to.
Parallel proceedings can't
Yes.
be done. Yes.
Now, before I am going to this my case fact. I have prepared a chart. First, my case, I want to show my case. My first read is this is against state tax. Before that, I am going to this second WPA 13008/2025. That is a today's writ petition before your honor. Here the period of dispute is 2017-18, 18-19, and show cause notice dated 26/7/22, and adjudication order 3/1/25. Demand is 2,73,44,891,00. Now I am going to the state tax. Against that, I was also filed the writ petition, WPA 2 writ petition. There are the 2 periods they have issued order 2. Therefore, 5169 and 5170. Here the same period, 2017-18, 18-19. Lordship got it?
Yes, yes.
Show cause notice 24/2/2022. So therefore, this same issue, so state has issued show cause notice earlier, number 1. Number 2, adjudication order also passed earlier, 31st December 2020. And their demand is more than that. Same issue, 5,39 lakhs. So my first submission is that when both the matters are same issue, same period, this is a total double taxation. It has to be decided where I have to proceed. That is my first crisis of this matter. Then I will go to the appointment notification, my secondary. If I first decided whether state will proceed or the central. Central is a low, amount is less. State is more, but I have to place before. There's a, for that very short issue, if your lordship take up this state also, state writ petition, as well as my show cause notice, what I have filed, these 3 to show writ petition would take up together, then it is very easy for us. If your lordship, what they are saying, I do not know.
And if issues are different, I think there is no bar.
No, they don't know the state. That is the reason I.
If your lordship, with the leave of my senior, if your lordship kindly see page number 173.
I am not going, 1 minute, I'm 1 minute. This is a fake invoice, I know.
Let him.
Page number 173, my lord. Paragraph number 9.3.
Yes.
Whatever my learned senior is making submission from the papers only. If your lordship kindly see.
No, I have
paragraph
not
number
complete yet.
9.3, my lord.
I have a
Sir, I
preliminary issue. 170.
In view of the whereas from DRC 01A, before issuing the suppose notice, we have issued that DRC 01A. In reply, my lord, what they have stated in reply above through DRC 01B dated by the notice, they have stated that 9.3, sir. Is number 173. In reply to of above through DRC 01B dated 24/5/2022 by the notice, they have stated as proposed notices have already been issued under section 74 of the WGST Act on the same allegation for the period 2017-18 and 18-19, covering all the supplies mentioned by your letters by the Joint Commissioners of State Goods and Services Tax Bureau of Investigation, which are presently sub judice. However, the notice have not submitted the copy of the show-cause notices mentioned above. Further, letters dated 12/4/2022 and email dated 1st July 2022 have been issued to the notice to provide the copy of show-cause notices issued by the state authority, West Bengal, but the notice have not submitted the same till date. Copy of DRC 01 be submitted, Sergeant sir. So, my lord, whatever they are making.
Only one answer.
From
what my friend is saying, Supreme Court already stated this issue.
My lord, I may submit. Now, whatever they are submitted, they have to substantiate by the documentary evidence. This is the supply, this is the subject matter of the show-cause notice by the state. They are not making anything who are in spite of repeated requests.
I will show
Now,
the
in
Supreme
connection with
Court.
the show-cause notice, my lord, in connection with this present show-cause notice, they have not filed any reply. What they have done, they have filed a writ petition. In the writ petition, there is no stay. Now, considering the judgment of the Honorable Supreme Court in the matter of Glasgow Smith, there is a Supreme Court has directed that if there is no stay, department have to proceed with the show-cause notice because it's a time-bound manner. I have to adjudicate the show-cause notice. They have not filed any reply.
Very attractive submission, but without substance.
I will come after recess.
Absolutely.
Take care. wanted to cut short this matter, therefore I have gone to this. But before that, when he has gone he has opened his case in this context. I'm submitting in my writ petition prayer is that some circulars I prayed for prayer for struck down. I'm challenging the virus in this matter. Do 2 points. One is that writ petition prayer. I'm reading prayer. Huh? My prayer is that, should I read, my lord, a declaration declaring that the proceedings initiated by the central tax officer being respond number 4-5 hearing issued by the show cause notice was and consequent orders are in absence of notification for cross empowerment under section 6 of the without jurisdiction. Second is that a writ of order in the nature of declaration declaring so many circulars.
Where is the judgment of the Supreme Court, which you said that?
Yes, I'm sure. No, just I'm appraising your lordship.
So let us come to the point immediately if there is jurisdictional error or not.
Supreme Court. Yes. My friend is saying lordship is aware. Thereafter, if that is so,
yes.
Here I have already read in and precise this. Here the investigation was challenged. Investigation was challenged by the central tax. In this context, Supreme Court said, discussed what is the proceedings, all these issues. Should I read some portion, lordship? If you
What has happened to the state matter?
SK Chakraborty, my lord.
No, the state matter.
In my case?
Yes, in this case.
This is still pending. Therefore, I am replying that.
That case also has show cause notice been issued.
Yes, that I challenge in the
Which one is
adjudication.
prior in point of time? This one or that one?
This is latter, earlier state.
My lord, the thing is that, my lord, in the pre-show
So,
consultation.
1 minute, আমাকে একটু বলতে দাও না ভাই, আমি তো আমার petition, I have to open my mouth.
Asking him
Oh.
if this is subsequent, then how could this continue after the earlier show cause being issued?
Lord, my submission is that, my lord, as it is, I have submitted paragraph 9.3 while issuing the pre-show cause consultation notice DRC 01A, the department categorically requested the petitioner to submit the proof that where is the show cause, where is their adjudication order has been passed with, so that they can come to the conclusion that there is no cross empowerment or there is no parallel proceeding. In spite of repeated requests, they failed to produce.
How was that informed?
I'm sure.
Now,
Admitted, one thing is admitted, I have informed him. Kindly, this judgment.
Not admitted. They say that they asked and you did not tell.
No, I'm telling you, lordship, I'm submitting. Kindly read para 97 of the Supreme Court decision. That is important. Para 97, lordship, got it? Last. We issue the following guidelines to be followed by in cases where after the commencement of inquiry or investigation.
Yes, Mr. Honjo.
My lord.
97C. It is your responsibility to coordinate amongst yourself and then take the information which is required.
That is my point. I'm grateful. I thought that I have argued that elaborately. That is when I'm intimated, and their
duty ends when they intimate. Once they have intimated, you are supposed to coordinate or communicate with the other wing and then take information as to what has happened.
Yes, lordship, I'm grateful. I'm grateful.
So this is the subsequent proceeding. This proceeding cannot continue.
The thing is that parallel proceeding, whether it is on the same subject matter or not, 6-2B to attract 6-2B, issue must be same, SSC must be same, the demand must be same,
right?
Subject matter must be same.
Right.
Now, What?
They
Yes.
are different.
This is the question. Therefore, my lord, the department has requested them. Now they want to, by citing this judgment.
You bring the other writ petition also.
Yes,
on
yes.
record.
That will be yes.
So that we can see.
both the matters can be heard together.
Lordship, you are kind enough. I have challenged in this matter show cause notice. That writ petition is pending. If your lordship clubbed all these three writ petition, it is easy for me. And otherwise
Which
it
is
will
the
remain.
earlier writ petition in respect of which the same proceeding you say has been initiated.
Yes, I'm saying so 1021. 212.
5169.
5168, that is the state. One is 516869 is the yes.
5169 and 5170.
Yes, these are the same issue. Both
And
are
one thing, my
adjudication
lord,
order.
Supreme Court dictum.
Another show cause, another in this matter, I challenge the show cause notice. That is WPA 21412 of 2022.
No, show cause notice is different.
Lordship, that is also a linked matter. That is the reason.
Now you are challenging order in original.
Yes.
In this matter only.
If your lordship is
very well.
Order that is challenging is from that petition where show cause notice is there.
Yes.
So both are same.
All are linked matter.
Earlier one,
we want to see whether both are parallel or not.
that one can see only from this one and the first.
Let all of them appear, because all will be decided.
And one
Otherwise,
thing,
if we can see that this is parallel and this is subsequent, then this has to go in terms of the Supreme Court judgment, and the other two will be tested. If I don't interfere with the order in original, if I interfere with the order in original, only then. Otherwise,
not pressing the wire.
My lord, technically I would say, if your lordship deciding the adjudication, but the show cause notice writ petition will remain unattended. That is the reason
that is all right. You are challenging the virus. You are pressing on the virus also, or if the order in original goes, virus is not.
Both I am challenging.
Then you have to issue notice.
Then lordship will what lordship is saying. Let us proceed on this way. I have to now urgent. I want to stay there.
Let them come first. Then that has to come first. This writ petition should be mentioned.
Yes. Let it come. No, I am not saying. Please, that all things are open. Lordship, let it come. Please, only one sentence I am putting. Why is so many words are not required? Both the writ petition would appear before the lordship, then lordship will.
My lord, in that event, my lord, I respectfully submit, my lord, state also necessary to be a party in this writ petition also.
No, state already.
State, yes. State has to be a party.
Challenging virus, both have to be added as parties.
Yes, sir.
And the state also answerable to your lordship, my lord, whether any
state would come.
No, state should be a party in this writ
in
petition.
This writ petition also state should be added as parties, because you are challenging a notification. That notification will have a bearing on both CGST, SGST. So both have to be heard.
I have already filed a separate writ petition.
That is different. In this case, you have challenged the virus. So here also you have to add them as parties.
And his main contention that similar proceedings initiated by the state are answerable in the writ petition also will say yes,
as
whether there
for by Mr. Das, learned senior advocate appearing for the petitioner.
Small lordship is observed.
Let us see 10th, 9th is 10th. It is going to appear. Let us see what happens on 10th. Chalo, call.
Not to take steps at least 1 day, 1 week. I'm not just I'm requesting.
Case has to be made out.
Case already made out. There is a violation of the Supreme Court judgment.
The
What
parties are
prima
not
facie?
here before me.
Parties are also not.
Chalo.
My lord, only one request. My lord, kindly put in third.
We are not entitled to get any.
এতগুলো না এটা দিচ্ছি
Deputy service.
No, this was mentioned as urgent motion. Have you given notice?
Sorry, my lord.
So then it will have to, you have to give notice and come.
My lord,
None appears for the
Item number 11, I am appearing. We have sought for the instruction from the department because they have challenged the show cause notice. Now, what is the status of that show cause notice? We have sought for instruction. We will be able to receive the physical copy also.
So when do you want?
My lord, kindly give us next Monday, my lord.
Very well. তাহলে none appears তো থাকবে না। Focus
And for the petition.
My lord, I am appearing on behalf of Union of India. Since there is no instruction, today I got this brief. So 6 time.
My lord, this is a matter relating to.
You had served notice on
Yes, my
of
lord.
the urgent mentioning.
Lordship, we have served the affidavit in service.
So that is of the writ petition that you have got it upgraded as urgent motion. We have served notice.
Not about upgraded motion, but
You
Lordship,
put the-
this
ah,
has
you
been done
mentioned it, you
yesterday.
Suddenly get it upgraded. How will they get ready?
Lordship, actually,
Not right.
Lordship, may I be allowed to say one thing? Your Lordship,
You are appearing for all the respondents.
No, only for respondent number 5, Union of India.
but Lordship, we have
And so
served
is appearing
copy
for
day
CGST.
before yesterday only. We have
CGSTs you should serve that you have mentioned it for urgent upgradation.
just done the service.
For upgradation, you have mentioned that you have intimated them.
But not about upgradation.
Then how will they come to know? Suddenly, if the matter is appearing at item number 349, tomorrow it appears as item 10. I would not have been ready if I had been on that side.
We'll
This is
serve
a
it
practical
today
difficulty.
itself.
Whenever you mention for upgradation, I have every time been telling parties who are mentioning for upgradation, please notify the other side. They will be caught unaware. How will they get ready?
We'll
It's
serve it
not right.
today.
Not done.
Lordship, today we'll serve it.
But it will not be taken up now this week. Although Union of India is represented, there is no representation on behalf.
Well, petitioner filed an appeal application before the appellate authority with the condonation of delay petition, but the appellate authority reject the application. Meanwhile, the bank attached for the recovery of demand, and till now the bank is attached for a recovery. Madam,
Yes, but there is an order passed in appeal.
yes, my
Isn't
lord.
it? Have you challenged that order?
I challenged before the appellate authority. Appellate authority reject on the limitation ground, and I filed this writ petition. Meanwhile, the bank was attached by the.
Very well. Appellate authority has rejected it on the ground of limitation. How many days delay?
208 days delay.
But page 15 shows 738 days.
No, page
Yes.
15.
1-5. This is item 12.
13.
Didi ki diyechen.
Prasad Das.
What is the ground for
Convention? Maharaj, page 45, the paragraph 4, the petitioner advocate Parthasarathi Gupta was engaged for the looking after all the matters, and Parthasarathi Gupta replied against the adjudication notice, and and then they prayed for the adjournment on his personal illness, and thereafter the 14/1/2025 the advocate of the petitioner died on 14/1/2025 and petitioner preoccupied with the treatment of his elder brother. He also passed away January 2025. And thereafter, the petitioner collect the documents from the advocate's chamber on 10/7/2025 and finally filed in 12/7/2025. That's why, my lord, delay of 208 days. My lord, the death certificate was attached, page number 31 and 30. 34 and 35. That is the death certificate of the advocate's petitioner, petitioner's advocate, and 35 of the elder brothers.
But this is not what was submitted. It doesn't appear that this was submitted before the appellate authority. Page 49. It was not the death of the advocate. It was citing death of relative. Page 49, third last paragraph.
My lord, this petition attached along with the appeal petition.
Yes, but look at what has been stated. Somebody appeared and made this submission. Death of relative has been mentioned.
Well, that is what mentioned in his application also, 45. 45, paragraph 9.
No. This is because of the petitioner's preoccupation and treatment of his elder brother.
Yes.
The previous paragraph. Concerned advocate delayed the process and the advocate passed away.
Yes.
So there are two reasons.
Yes, sir.
Yes,
One reason is. But only thing, my learned friend, that the learned advocate was dealing with the matter, but at least in the order portion, it says that there was only application for condonation of delay. There was no, there was never a reply on merits. There was never a reply. So that concerned person was not dealing with the matter for a long time.
So that may be the ground of illness, but at least
but there has to be some consideration.
Delay has to be. I am remanding it back to consider the condonation of delay application afresh.
Oh, my lord.
He will consider and pass because there are two grounds.
Yes.
He has only considered one of them. The advocate itself has passed away, and there is copy attached. This has
yes, well, some
this has not been considered at all.
Absolutely not.
So this should be considered by the appellate authority. I am not condoning the delay right now. Go before the appellate authority. Let this be considered.
My lord, only bank attachment. Kindly withdraw the bank attachment.
The appeal becomes alive. Then how did the bank attachment?
Yes, it has to.
Because
Well, one instruction, please noted.
yes,
The
I will. I
Okay.
will say that. This Yes.
My lord, this is the identical matter, but this appeal not rejected till date, but bank is attached by the authority concerned, and the
How can that be if
page 44 bank attachment notice.
if pre-deposit has been
But
Yes,
sir,
my
all
lord,
delayed.
proceedings are already-
Sir, all delayed. So, my lord, it is what happened, my lord. My instruction is DRC 13 was issued 1 p.m. on 18 November. They had filed the appeal on the same date in the evening, 7:52. And the adjudication order was passed much prior to that.
adjudication order is 21st of February 2024.
So, my lord, they had waited for a 1 year. They did not take any steps. On the date of the attachment, my lord, they had filed the appeal.
No, my lord, the petitioner bank attached on 20th 11/2025, and the petitioner filed an appeal 18th November 2000.
After two days prior.
2 days
So
prior.
why after 1.5 years?
My lord, the petitioner's wife is under treatment, and after that he filed the appeal
This is an
petition, and the
obligation by the bank to the assessee. The attachment was done prior to that. My specific instruction 4 and 5, where at 1 p.m. my lord, it was done. The upper my lord, top, the first 5 paragraphs, my lord, 4 and 5, my lord, the first.
The appeal has not yet been taken up for hearing.
No, my lord. My lord, petitioner's other year, this is the year for the 1920, 1819 petitioner filed the appeal and appeal rejected. The honorable this court passed an order for the same petitioner. Huh? এই পার্টিরই
And I think the bigger point is the attachment. Bigger point is the moment.
No, but here the appeal was filed much prior. February 2025 appeal was filed.
Yes,
in this
order
thing.
Yes, my lord, thereafter the petitioner filed the next year
order was
appeal,
on-
and
Order was passed in July. Filed
No.
it in
Order was subject to amendment February 2024.
no, that
Oh,
is
July, 8 July.
8
July.
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 8 July.
More than a year. I'll leave it to you.
For the same petitioner, my lord.
And how many days delay is here?
408 days delay.
408.
Yes, my lord.
So here delay was lesser, much less. Here delay was 196.
Yes, my lord.
408 is more than 1 year. This will not help. This is too much. Pay some costs. 400 days delay, more than 250. Cost.
My lord.
But appellate authority has not yet considered also.
No.
So what cost? What to do?
My lord, consider the delay and withdraw the bank attachment.
They have to consider first. They cannot
Can
be
you
the first.
leave the attachment? Because he has paid the pre-deposit. But once the pre-deposit is paid, this.
लिखे नहीं, इटा लिखे नहीं. The petitioner alleges arbitrary action on the part of the respondent STST authority, respondent state GST authority in where is the order of attachment?
My lord, page number 44.
In attaching the petitioner's bank account. Now, attaching na kore in issuing garnishee notice. Garnishee notice. Garnishee notice.
My lord, may recollect that there is only short question whether the time has been given, sufficient time has been given or not.
It's a question.
Only for doing the appeal, for conducting the appeal.
What?
In appeal, 3 hearing should be given in section 75.
Question was regarding that whether any opportunity of proper hearing was conducted or not. If your lordship kindly comes to page 457 as the appellate authority's order.
457.
Yes, your lordship.
It starts with 456.
It starts with 456. The relevant portion is 457.
457.
17/11/2020. If your lordship kindly comes to fourth dotted portion, as the appeal was filed in compliance of section so and so and so and so, same was admitted in the form of GST APL 2 as prescribed in 100, issued on 17/11/2023. 17/11/2000. Kindly me to bole nahi, because lordship has instructed. 17/11/2023 is the crux. Is the starting point when there. After that, I have received instruction that officer has been transferred. New officer came in. He joined in March 24, and in March from May to October, some earlier petitions were there, so he wanted to dispose those petitions. Now, after that, 2 adjournments were given.
No, there's one hearing fixed on 12th of December also.
12th of December, but that officer was not there.
Okay.
The new officer came into, and your lordship, another hearing was given on 17/9/24 and 24/9/24. In the meanwhile, appellant after 24/9/24, appellant had sent 2 emails on 26/9/24 and 27/9/24, where they have not mentioned anything about. Your lordship, I have got the copy of the email also. I'm sorry, I'm not carrying the hard copies. They have not. Phone email.
Your document produced
26, 24/7 following attached are the documents.
I'm providing.
I can show you. 26/9/24, with your kind reference, documents are sought by you for your kind perusal. In case of further clarification data, feel free to contact us. This is the first email. Again, on another date, 27, they have sent another mail. So there is no whisper of any further. They could have very well asked in the email also that I have not concluded my submissions. Kindly grants us time. So there is no whisper iota or a whisper even in these mails, your lordships. And my learned friend is raising the contention that particular time period is fixed for hearing. Lordship, the section particularly says if it's possible. On the last occasion only, when I was taking your lordship through the section, if it's possible. So that possibility cannot be subject to certain conjecture and surmises. The possibility he has been transferred. My contention is that new officer came into being. New officer, there was a new officer. After that, he has tried his level best to provide him opportunity. The onus was on the appellants themselves to ask for further time.
You file a short report in the form of affidavit because these things are factual. These should come on record.
Absolutely, Your Lordship.
There is an allegation of not granting him opportunity. That is the only point.
That is the only point.
Very well. File a short report in the form of an. The petitioner, this writ petition
Learned, respondent authority, learned court has given 12 weeks time to complete the appeal. We are not in a position to prepare the documents within 12 weeks, but respondents are saying that the 12 weeks guideline is there, so you have to give the 12 weeks time. In this respect, she has mentioned, then my lord has pleased to tell that file an application for that. That application is filed. That application is in the list. 323, 324.
It
307
will
and
be taken up whenever it is called on.
No, but-
Next matter, because time is flying.
Huh.
Don't mention now.
16.
Yes. 16. 17 बोल
Well, 17, I am for the petitioner, my lord.
No, 16. Yes.
My lords, this is that matter, my lords.
My lord was hearing this matter on the earlier occasion, that regarding section 61 and bunching of.
Yes.
My lord, he wanted to say something more before I continue. I've gone through the judgments, I've prepared my notes. I can carry on, but it will take a little time. My lord, we taking up.
Up to you. We can continue for.
So he's on his way. We can get started, my lords. So
Or my lord keeps it on, as he was saying, on 8th.
On 8th.
As Mr. Abhutosh Majumdar is not there tomorrow.
So, my lords, he
But
was on
my
his legs.
only
What I've been
difficulty-
told is he is done with his matter. He's on his way, and anyways, I can.
My only difficulty is that adjudication has to be completed by 31st December.
Hmm.
Now, if my lord has the previous order had said, since this court is hearing this petition and the hearing has not been concluded today, the respondent authority who is to conduct hearing tomorrow, that is on November 7, is request to postpone the said hearing to a date later than the date on which the instant petition is made returnable. So, my lord, my humble submission is, if my lord only says this much, that let the hearing continue, let the order not be passed without the
My
leave
lord,
of court.
The only difficulty is, my lords, the points which are merging is entirely on jurisdiction. So, my lords,
No, I'm not asking them to pass an order because there will be
No.
a time barring thing.
My lords can-
It could
And
have been
even
taken
if
up
the order
earlier
is-
also. Mr. Majumdar
will take time.
and Mr. Kundalia both came and mentioned that it should not be in the next. I had kept it immediately
yes, my
in
lords,
the next week.
absolutely, my
But
lords.
then it could not be taken
It could
up.
not be taken up.
So because you all wanted it to be on a different day, I had to fix it because it was fixed on a particular
My
day,
lord does only this much.
November 13.
Let the
Taken
order,
up on 6.
even if the order is passed, let that order not be given effect to without the leave of court. That is good enough.
That can be done.
Because,
What's the
I
difficulty?
leave it entirely to your lordship, my lords.
My lord passes that order.
But my lords, my lords will be keeping this for the
On
8th.
Mr. Majumdar is also here. Let me also hear it so that things are clear.
Right.
Let the order be applied.
Not
order
not be passed without. Yes, ma'am, we are agree.
As
30 days no टाइम नहीं चाहिए होगा
My lord, may I be allowed to do for 2 minutes, my lord, in item number 12, they have served through the data and apologies, my lord. That is my mistake that I am saying.
Very well, it is appearing again. Don't.
Okay.
What you mentioning in the original file? What application under Article 56, item number 1?
Milord, today the other side has requested for not today. So, Milord,
Not today.
Milord, may it retain the.
Yes, it will be
much.
wherever it is.
Item number 2,
Not today, Akiji.
item number 3,
Finally, Mr. Banerjee is there.
I tender my apology, Milord.
No, no, not at all.
Collector Calcutta passed the order.
Yes, Mr. Banerjee, is there any new right created? Why should stamp be imposed? Because partition, if it is only arrangement of rights, then in that case stamp duty need not be.
So there's an entry 45 prescribes Milord a stamp duty. Deed of partition or decree of partition or order of partition.
Decree
Yes, yes. It mentions Milord any
There is
instrument
a
or
recent judgment of Supreme Court, very recent. I think authored by Justice Mahadev. Very recent. I saw it a few days back, where it has been said that you cannot. Show me the act, Mr. Banerjee, if you have. Because the law is that you will impose stamp duty only if a new right is created.
Yes.
Somebody is getting a right, somebody is being divested of the right, and that title is being got by somebody. Then in that case, yes, there is change of title, and therefore, but here it is only arrangement. The person has right. The co-sharer has right. It is not that he is getting title because of the deed.
no, Milord, shares are separated. Portions are
That
separated.
is only separation.
Separation.
The right is there. Right is there.
Right is
Now,
there.
if
Right
no
to
new right is created.
right
then in
to
that,
occupy a particular portion.
but
He has
that
a
is
right.
that is not title to the property. Title is already there. It is undivided.
Yes. That
Title to the property is there. It is undivided.
Undivided.
The only
So-
difference that is taking place is that there is a
He
division.
is acquiring specific right, undemarcated, undivided right in a
No, but
particular
that is
portion.
not creation of new right.
Milord, subject to
amongst
correction
the
by my lord, Milord, might
that's
not
right.
be a new right, but any kind of right, if it not comes under the Milord, various entries in the schedule of the Milord Stamp Act, the entry is not
No,
been
but this
challenged.
has been, Mr. Banerjee,
Entry
subject
possibly
to
45
correction
has
by
not been
both
set
of you.
aside.
It has, I think I have gone through such judgments where it has been said that there should be creation of a right for incidence of stamp to be levied,
Yes,
incidence of duty. If there is no creation of the right, is always there. Right was there with the person. It was in an obscure form. The only thing which has been done by the partition deed is you have given clarity to the right. This is the partition by metes and bound. You have specified the boundaries, but it is not that you have granted or conferred a right. Right was already there. It was there in an undivided form.
Milord,
It was always there.
the schedule also prescribes for deed of declarations also, Milord.
No,
Then that
Mr.
will also
Doctor,
go.
it's an
if
Article
interpret it
45,
that way,
my lord,
Milord.
if it your lordship kindly correct.
In that case, Milord, 45, Milord, he will say that 45 goes. But he has not challenged 45. So these Milord entries in my humble submission, Milord, are instances
My lord,
where
I
the
have
government
challenged
thought
both,
it
my
fit.
lord.
No, yes,
If
you have
your
challenged the adjudication, not the entry itself. So these are instances as per the government where, Milord, stamp duty is leviable under the Act. No, if not, there's he's saying that 45 situation doesn't require any stamp duty. In that case, he'll have to challenge the entry.
I relied upon section 2 subsection 15. This is not an instrument of partition. The final degree declared by the Honorable High Court, my lord, there says, my lord, the partition is not possible. And the assessment, I have raised objections. It was twofold, my lord. First, my lord, they levied stamp duty on Article 23, sub-article 2, perhaps, and that was waived by the subsequent.
Which one? Please tell me. Where are you?
My lord, the assessment order, if your lordship kindly takes up the
No, if you see Article 45.
45 and read with section
215.
250.
Subsection 15.
215 also contains or the final order for effective partition passed by civil court.
Lordship. My lord, that has to be a final order affecting the partition. Here, my lord, the final order has been passed, saying that partition is not possible. My lord, I have annexed the final order. If your lordship kindly consider, the final order decree, final decree has been passed. My lord, at page 87 of your lordship. Here, page 88, page 88, paragraph 5.
Page 88.
88.
Yes.
Paragraph 5, my lord, this is the final thing passed by the Honorable Court in a partition administration suit, where the co-sharers sought for partitions. But after the structural engineer come to a finding that the partition is not possible because of dilapidated conditions of the entire building, and building is 100 years age old. So, my lord, the final degree has passed in that way, my lord, taking into consideration the existing right of the portion. And exactly same thing happened, my lord, as your lord has fallen from the lordship's, my lord. I could not consider the latest judgment. On earlier occasions, my lord, the Supreme Court as well as our Honorable High Court has proceeded in that way only following that test. If it is not a partitions and the creation of a new right, so partition, I mean the stamp duty under Article 45 should not be attracted, because it is not a.
You have that judgment, new right.
My lord,
I have also read it.
I think I should not go through it and come back, Lord, because
I have read it, and there is a recent one of Justice Mahadev.
In that case, my lord, the entries, particular entries, some of the entries will go because a deed of declaration.
I have seen it in light.
Right is created, but
it
attracts stamp duty.
Not retrieve it.
Justice Mahadevan judgment.
Lordship.
Yes.
It has come up in the.
It was in context of Madhya Pradesh property.
Correct.
Madhya Pradesh property. I have read it. Recently, I read, maybe 1 month or
it is
around the puja.
Come up in the.
Kindly allow us to go through and come back with the judgment.
Because
I'll be placing
that is settled. That it has to create,
and it is an age-old
incidence will be on creation of a right.
Fine.
If there is no new right, that does not make sense. I already have right. Merely because somebody says that this is your right, I'll have to pay stamp duty. There has to be exchange.
Correct. Now here, these instances have been
because incidence, Mr. Banerjee, of tax is on transfer, right? It's always on transfer. When you already have a right and it is only a question of it being specified or demarcated, there is no transfer. So how would tax be applied? How would stamp duty be levied?
What is happening in this case, particular portions are demarcated.
Yes, but Mr. Banerjee, that demarcation, if you say that yes, by dint of demarcation, there is a transfer also included, then in that case you have the right to impose stamp duty. But if no transfer is effected,
My lord,
My lord, in my humble submission, my lord, kindly looks at it from this angle. In a partition, my lord, if A and B, they are getting, my lord, complete share in two portions of a property. My right of title in the share allotted to me, that is transferred by the other person, and his right in the portion allotted to me is transferred vice versa.
there
In
is
case
no
of a
such
partition,
allocation.
not only a declaration, because I have title over each share of the property, each inch of the property. I have right. Now I am transferring my title.
No, but you have right over each inch of the property till such time that you consume 50% only of the property if there are two co-owners. You cannot have such right that each inch of right over each inch of the property would mean 100% of the property itself. That will not mean. No, you will have right such that he also has right over it. So both of you together constitute one whole. Both of you together constitute 100%. So this leads to implicit in this conclusion is the conclusion also that individually you have 50-50% because both of you constitute 100
shares undisputed.
Therefore, your right
ownership in property is not specific, area specific.
Yes, therefore there is no transfer of right, transfer of property. There is no transfer of property.
Kindly consider this, my lord. My title in particular portion of the property, I am foregoing for absolutely in favor of the other allotee, and his share is not transferred in my favor. That is why I am getting
That is not the case here.
It's only demarcation.
That is not the case here.
There is no creation of
demarcation. What I am getting, my lord. Initially,
by way of demarcation, you are getting by way of demarcation, you are getting specificity. That's it.
True. But lot A, lot B. Before partition or demarcation, I had title in both lot A and lot B, entire property. After demarcation, lord, my right or title in lot B ceases, and his title over lot A also ceases, and I acquire absolute title over lot A. He acquires absolute title over lot B. So there's some exchange, some sort of exchange. That is why a particular rate has been prescribed. Highest share on that 0.5% or something like that has been prescribed. Not like a sale, but some transfer is there, my lord, inter-sale. My share in his lot is transferred to him. His share in my lot is transferred to me. Rather share and lot absolute share. So I am getting the entire lot without his.
There is no creation of right, but there has to be a creation of right. The right is there is no new right created.
No new right.
But that is the incidence of taxes only when
kindly allow me to go through the judgment vis-a-vis entry 45, because in that event entry 45 becomes
when do you want?
After a week. I'll go through.
Main difficulty to find out Mr. Bennett.
No, he'll come now. He has found interest in this.
I shall bring that judgment.
As prayed for by the learned advocate for the
আমাদের নাম দিয়ে দিচ্ছ? I'm grateful.
My lord, may I be permitted to appear virtually in the instant case, my lord?
Yes.
Well, this is the case, my lord. I have imported, my lord, PVC flags from China, my lord, upon payment of the customs duty. Thereafter, my lord, the DRI conducted investigation, my lord.
The department had filed appeal before this honorable court. The department has preferred appeal against
what?
Order.
My lord, what I have come against, my lord, inaction on the part of the respondent authority, my lord, in not refunding my money, my lord, which arises out of the order passed by the state, my lord. What happened, my lord? I paid 44,11,000, my lord, during the course of investigation and search and seizure, my lord. Thereafter, my lord, the authority passed an order in original, appropriated the said amount, my lord. Thereafter, I went before the state, my lord. State, my lord, set aside the order in original, my lord. Now, against that order, my lord, they have filed an appeal, my lord. I have come before your lordship for refund of this rupees 44,11,000, my lord, which arises out of the order passed by the state, my lord.
Mr. Day is not comfortable. Some personal difficulties.
Mr. Dugar, Mr. Day is not here. He
Yes,
said for some
I heard, my
personal
lord. Then, my lord, no, my lord, kindly fix it next week, my lord. Tomorrow I am traveling, my lord.
next week.
But appeal is pending, my lord.
So what? That was pending. That you sought for time on the last occasion, Mr. Day sought for time to take instructions. Ask him. The appeal is pending is not an answer.
And my lord, appeal has been filed, my lord, knowingly well that it is below monetary limit. My lord, my lord, circular was issued that if the threshold limit is below 1 crore, you cannot file the appeal, my lord. The department cannot file appeal. Despite that, my lord, withhold.
An adjournment is prayed for on behalf of the respondents. Full stop. List this matter for further consideration on 8th December.
I'm grateful, my lord.
Item number 5.
Lordship, I'm appearing on behalf of the petitioners. Lordship, I'm being led by Mr. Odiji Chakraborty, but he's on legs before court room number 5 for a fixed matter, Your Lordship. I was praying for an adjournment.
When do you want?
Any day after the 10th, because Your Lordship, I've also further instruction that he will not be in town.
An adjournment is prayed for on behalf of
Alternate actually, it usually doesn't appear with, if it doesn't have a matter. Doesn't come. That doesn't come.
Appealing my lord is meaningless because of huge.
Grateful.
Grateful, Lordship.
This matter also, Mr. Day is appearing.
He has some personal difficulty, I'm told.
not today or not this week.
My lord, then my lord, can it be posted on, my lord, the week commencing, my lord, 23rd or something like that, subject to lordship?
23rd, then monthly list of January, because 23rd, nothing
could be. কতদিন আসতে পারবেন? মানে next week আসতে পারবেন? Then let it be 9th, my lord, we come back. But if
এটা 9 তারিখে দিয়ে 9th.
But in case, my lord, I'm otherwise, my lord,
Yes,
there's
yes,
some
not a problem.
difficulty, my lord.
I'm not passing any order, then it will appear on 9th.
Yes, yes.
Or should I pass an order? 9.
My lord, 8 is a connected matter with 6 as well. It comes from the same impugned order. My lord, if my lord's keeping it on 9, this can also be kept on the same.
Did you 5 or 7? No.
My lord, 8, 9, 13 and 14 all are connected to 6. 6 is the main petition by the main petitioner.
6 se ki order pass hoye jodi?
The one that
Mr. Mojumdar was there.
9th.
9th.
So there is no order passed. It will appear on 9th.
9.
9th.
8, 9, 13. 8, 9, 13, 14.
14. There is no order passed. All of them will appear on 9th month.
Item number 10.
You know, the Lordship had heard this matter previously. Your Lordship, if I may just briefly recapitulate for my Lord's convenience. The matter pertains to Your Lordship the initiation of proceedings under section 148A and the issuance of the notice under 148, which we are saying is without jurisdiction. As my lord, that there is no information or material against the petitioner. Plus, your lordship, the issue that was raised in the notices, the case made out in the notices, is different from what has been written in the order, and that itself is the basis of showing that the proceedings are without jurisdiction, as the entire formation of the belief or the basis of issuing the 148A notice, that goes. Now, my lord, the petitioner before my lords is a central government undertaking. It functions under the control and management of the Ministry of Petroleum. My lord, the petitioner is also engaged, your lordship, in providing logistics services and also of travel travel agency, your lordship. Your lordship, in the course of its functioning as in the business of travel agency, your lordship, the petitioner also provides travel insurance facility to its customers. That travel insurance facility is provided through an empaneled set of insurance providers. Your lordship, one such travel agent is Reliance General Insurance Company. Now, my lord, the department had initiated search and seizure proceedings against some third party. In the course of that search and seizure proceedings, it was found that, my lord, that certain people are engaging who the department states are middle layer business entities. My lord, they are basically acting in cohorts with certain insurance companies, wherein your lordship, commission is being given by the insurance companies to the intermediaries or middlemen, which is in violation of IRDA laws. Now, firstly, to even insinuate that it will be applicable to another central government agency is preposterous. Besides that, your lordship, the allegation was with respect to one Reliance General Insurance Company. While the material that was provided to me was all pertaining to Reliance General Insurance Company and the transactions pertaining to that. No, not the transaction, your lordship. In fact, there was no basis disclosed with respect to my transactions as to how because of my transactions, income chargeable to taxes escaped assessment. So it was all said that all the material was pertaining to Reliance General Insurance Company. My name did not feature anywhere in any of the material provided by the department, except in one list of vendors. So, your lordship, I will be one of the vendors of that particular entity as I'm doing a business transaction with them. It's a listed company, your lordship. So, except that, there is no material, the statements provided don't mention my name. The materials provided, the dissemination report of the investigation wing provided does not mention my name anywhere. I filed my submissions, your lordship. First submissions were filed. In the first set of submissions, your lordship, I provided details of all the, my lord, payments that I have made to Reliance General Insurance Company. The department issues a second notice, says that I have not understood the nature of the transactions. It doesn't match with their data. This time, your lordship, I filed all the details of the payments received from Reliance General Insurance Company. Thereafter, your lordship, when the order is passed, the order says that it mentions Reliance General Insurance Company, but it says that it is because of the fact that I have transactions with one Prudent Insurance Company that income chargeable to taxes escaped assessment. Now, your lordship, I have had firstly no transactions with Prudent Insurance because, your lordship, my transaction, first of all, the department's allegation in the case made out and the basis of initiating reassessment proceedings was all along some alleged transaction with the Reliance General Insurance Company. The nature of the transactions were also never disclosed in any of the notices. I provided all the data available to me. I provided supporting evidence, invoice copies, everything. And I even submitted that, your lordship, as far as the payments are concerned, I am only acting as an agent of my customers. So whatever money I'm receiving from the customers is directly being given to Reliance General Insurance Company on the basis of invoice issued by them. The invoices being issued by them is also in the name of the customers, and it only mentions my name as an agent in those invoices. So all of that data was provided by the department without considering anything. They've passed the order and they made out a completely different case. Now, my lord, when the allegation of prudent has come, but before filing this writ petition before the honorable court, I've ascertained that I have no transactions with prudent. The only way prudent comes into the picture is that, my lord, prudent is actually only an agent of Reliance and they are involved in making these invoices. But there is no transaction between me and prudent. The invoice itself says that the payments are to be given to the credit of Reliance General Insurance Company. And the payments have been made to Reliance General Insurance Company by taking it from the customers who are availing the business of the travel. And my lord, even the notices that were issued all refer to Reliance General Insurance Company. There is one verification details, my lord, which is generated on the portal. The source PAN mentioned in those notices is also of Reliance General Insurance Company. But the case is completely different. Now, my lord, if I may take my lords again just through the papers once to show my lord as to what the department has, how the department has conducted itself. Because your lordship, the settled proposition of law as far as 147 proceedings are concerned or reassessment, my lord, the proceedings are in the nature of reassessment, not review. My lord, department cannot sit and review anything. And my lord, once the time period to initiate assessment proceedings are complete, my intimation order becomes attains finality and that becomes my assessment. And secondly, your lordship, for initiating any reassessment proceedings, there needs to be information in the possession of the department, tangible material. And the department needs to mandatorily draw a live link or a nexus between that information in their possession and escapement of income. The Honorable Supreme Court has also laid down on n number of occasions that not any and every material becomes information. There needs to be this live link or an intelligible link between that information in their possession and how income has escaped assessment. No matter if I may now just take my lords through the papers once. My lord may first take
page 87.
My lord.
You had said nature of transaction was not mentioned.
It doesn't, my lord. If my lord may kindly take the information, it says the second paragraph from information, it says information contains that your company has made transaction with following insurance
In the
companies.
last occasion, you had said that nature of transaction has not been
Not mentioned, but my name is mentioned as Reliance General Insurance Company.
Yes.
That's about it. Now, my lord, after that, at page 89, my lord, that is the case-related information detail. This is, my lord, generated on the Insight portal, uploaded by the departmental officer. My lord will see in
Reliance
information detail.
DICL complete data.
Yes, your lordship. No data available under specific information and information details, my lord. The source PAN is Reliance General Insurance. So their case is always Reliance General Insurance, your lordship. And they are referring to general documents. Next, your lordship, is a dissemination note which is prepared by the investigation wing. My lord, page 91, it says that some search was conducted on middle layer business entities. And my lord, it refers to one Wings Brand Group and Ajay Mehta Group. And this report does not mention my name anywhere. So therefore, this information also does not pertain, this material does not pertain to me, cannot be regarded as information. Next, your lordship, is my chapter 28 at page 100.
Page 100.
My lord, this again, my lord, this particular document does not mention my name anywhere. Thereafter, my lord, I was provided with statements which are at page 128.
Yes.
These statements, my lord, at page 128 onwards, these statements also, no reference has been made to me. So none of these material pertains to me. There is no material against me, let alone my information and intelligible information. There is no material against me. But the only place, as I mentioned earlier, your lordship, was that there were list of vendors at page 162, my lord. In that list of vendors, I am one of the vendors. And we'll see details of large marketing vendors. I am one of the vendors. It doesn't mean that any person they've had a transaction with, it becomes a income chargeable to tax escaping assessment. But I filed my first reply, my lord, on 9th April 2023 or 2025, your lordship, at page 193.
Page
193, my lord.
193, yes.
At page 193, Your Lordship, we've pointed out that we are a central government undertaking working under the control of the Ministry of Petroleum. Then, my lord, we've given the entire details of the transaction, my lord. We've spelled out that we are an agent, that we are active in the business of travel, providing travel agency facilities, and that we are providing insurance facilities through empaneled insurers, and that the payments are all getting directly are being collected and are being paid to Reliance General Insurance Company. And my lord, page 194, well, we've given all the supporting documents, my lord, including, my lord, sample policy issued, details of payment. My lord, the entire details were provided, even the CAG report, nil CAG report was all provided, Your Lordship. My lord would see that, my lord, I have even provided a reconciliation of the payments and the transactions at page 196. And my lord, a sample invoice, my lord, is at page 198. My lord has page 198. My lord, it says, my lord, at the top left-hand corner, name of the proposer, Balmer Lorry Company. So I'm only a proposer, but the name of the person for whom this insurance certificate has been issued is one Shovik
The name of the customer.
It's the name of the customer. I'm just, my lord, the proposer. And my lord, the nil CAG certificate also is enclosed at page 220. That I've been audited by CAG, and my lord, there is no
page 228.
220, Your Lordship, 220.
220.
This is a certificate, man, because I'm subjected to audit by CAG. So when they find everything in my accounts to be proper, they say that we have no comments and no remarks with respect to your audit, which is being done by the statutory auditor. Thereafter, my lord, the department issues the first notice at page 221. Page 221 and page 222. Yes, just to show that there is a change in incumbency. So the officer who started the proceedings is now different. There is a different officer in charge. Then, my lord, at page 223 is the second notice, the second effective notice. At page 224, my lord, he gives me a response to my detailed reply, my lord. He says, please refer to your reply dated 9th April 2025, submitted in response to the show cause notice dated 30th March 2025. Your reply does not correlate with the notice and information shared with you. Therefore, information is again shared with you, and you are requested to submit your reply within the date mentioned in the notice. So, my lord, when I've given all the details with respect to all the payments made to Reliance, now I'm giving all the details, my lord, with respect to payments received from Reliance. My lord, will you kindly take my reply at page 225.
Yes.
My lord, again, my lord, I reiterate some of my objections, but my lord, the nature of transaction is where I have explained the kind of receipts from Reliance. Now, there I've explained, I have mentioned two facts. One is I get commission. The second, my lord, is that the petitioner has various hoarding spaces and various advertising spaces available, because it's also in the business of logistics. So, my lord, on its premises, it has allowed Reliance to put up advertisements. So it gets money on account of those advertisements, Your Lordship. And that entire details, my lord, are provided to the department at page 229 onwards, my lord. 229, my lord, is with respect to the commission, and page 230 is with respect to the holdings. And my lord, I provide sample copies from page 231 onwards. My lord, now this has been dealt with by the department, but subsequently, all the supporting documents, Your Lordship, copies of various invoices issued. My lord, the department has passed the order under 148A3. My lord, that is at page 278.
278.
My lord will see at page 279, my lords.
Yes.
My lord, does my lord have page 279, my lord?
Yes, I have it.
But paragraph 2.3, it says the information as made available in the inside portal is that the assessee company has made transaction with the following company during the year under consideration, which is not in accordance with the provisions of IRDA. Therefore, such transaction is suspicious in nature. He refers to the transactions with Reliance General Insurance Company. Then, my lord, he gives a description of the show cause notice and the reply filed. He's reproduced, my lord, the parts of the reply. Then, my lord, at page 283, my lord.
Yes.
But 283 says, as per the information uploaded, Mumbai Circle, rupees 7 lakhs as commission received directly from Reliance General Insurance Company and further received rupees 1 crore 2 lakhs 41,800 through an intermediary, namely Prudent Insurance Brokers Private Limited.
The name of Prudent Insurance doesn't figure anywhere in
Nowhere, your lordship. And my lord, even the conclusion, but even after that, he says, my lord, he provides one table. After the table, my lord, he says, however, on perusal of the submission filed and the documents furnished in the course of proceedings under 148 of the Act, as evident in table A and B above, it is shown that the receipts from Reliance General Insurance, totaling to rupees 1 crore 10 lakhs 33,116. However, no detail has been furnished with respect to receipt of 1 crore 2 lakhs 41,800 from Prudent Insurance Brokers. Further, in the course of proceedings under section 148A of the Act, no submission, clarification, explanation has been filed with regard to such transaction, although all the information available with the office were provided to the assessee company. However, it is pertinent to mention that the assessee will be given sufficient opportunity, sufficient and reasonable opportunity to furnish explanation or documents on the above issue in the course of the assessment proceedings. The current proceedings is just the beginning of an assessment proceeding and not an assessment. Then, my lord, at paragraph 6.3, my lord, after he records his conclusion, while he's recording his conclusion, he says, accordingly, in the present matter, I am satisfied that there is an unaccounted receipt of rupees 1 crore 2 lakhs 41,800, which is found to have escaped assessment as per the provisions. So, my lord, my humble submission is that the name of the prudent was never his case. He never did not initiate the proceedings under 148 on the basis of my alleged transaction with Prudent, which is in fact non-existent. It is an imaginary transaction. And my lord, the nature is never mentioned. For the first time in the order, he's referring to Prudent. And for the first time, your lordship, he's saying that I have received such money, whereas I have not received such money. My lord, reassessment proceedings, my lord, it is now settled law that even to issue a 148 notice, my department needs to conduct some sort of verification exercise at their end prior to starting reassessment, because it is not a fishing or roving inquiry that they can conduct. But the moment they get any information from the investigation wing, it becomes a gospel truth. And my lord, they will issue notices to all the persons with whom that particular entity has had transaction. They must conduct some inquiry, draw some link between my lord, that information in their possession and escapement of income. Otherwise, it becomes an arbitrary exercise of power. And my lord, earlier, my lord, all this was codified, was settled jurisprudence. Now, my lord, even the Act says that section notices under 148 and 148A will not be issued without information. And while issuing a 148A notice, the assessing officer is bound to provide me with the copies of the information. In this case, your lordship, there is no information at all. And my lord, with respect to, and then my lord, also, my lord, may kindly take the approval, my lord, that has been issued at page 275, your lordship.
Page 275.
My lord. My lord, here, my lord, may kindly take page 276. My lord, my paragraph point number 16I, my lord, which is the approval or the observation of the, my lord, specified authority. He also doesn't give any reasons.
He agrees with you.
He simply agrees, my lord. There is no examination, no nothing, no independent reasons given. And a simple concurrence will not amount to a reason, my lord, or a proper satisfaction being recorded.
No, if he agrees, he is not required to give separate reasons. If he doesn't have any separate reason to offer and he agrees with the assessing officer, then in that case, non-giving of reasons in such a case will not vitiate his order.
He needs to show some examination of my submission. That
this will suffice because this is only an approval, so it need not be in the format of a judgment. He has agreed with it upon going through the documents, but yes, that ground of yours need to be answered as to what is the information on the basis of which and why has this not been provided to you, because that in that case you are being condemned without being heard on this prudential or whatever the name is, prudent insurance brokers aspect.
In fact, my humble submission of the entire basis in this shows that today, when he's issuing a notice.
Because the notice is punctuated with Reliance.
My lord.
And suddenly he makes out a new case in 148.3. That is something which is Mr. Sharma to answer. Yes, Mr. Sharma.
First of all, my learned friend had made a submission that this is a PSU. This PSU not subject to.
No, that is there. It's there. But
No,
what
my
is the
learned
basis?
friend was harping on that particular PSU. Second, my lord.
Usually they won't take accommodation entries.
I know.
That was his submission.
I have, but my lord here, there were two types of transactions. The assessee was with the Reliance. One was providing insurance to the customer through, and they were providing space for holdings. What was the search and search case was that these company, insurance company, in the cargo, other charges were paying excess commission to whom? To different buyers or agents. For insurance, there are some certain agents who are given commission. Our IRDA has made rules that which has fixed that up to a certain percentage commission can be. But this insurance company, in order to procure more business, they have to subvert means. So this was all the search report. On the basis of that, the case was read. Where the assessors admitted that they were transacting as an agent of Reliance General Insurance Company.
Who has admitted?
Assessee.
The petitioner?
Petitioner.
Where?
My lord. Kindly come to page, my lord, 4 of the writ petition.
Page 4. Page 4.
Yeah, my lord, I'm reading. The petitioner said that it is engaged in multiple businesses which it conducts either directly or through subsidiaries or joint ventures. One of the business activities of the by travel services, including air travel services to its customers. In the course of its air travel services, your customer often seeks air travel insurance, and the petitioner facilitated the same through its in-panel insurance, which includes and general insurance company. Your petition said that it merely collects the amounts from its customers and remits the entire sum to Reliance General Insurance Company, and insurance policy is also directly issued under. For facilitating the transaction, the petitioner receives commission from Reliance General Insurance Company. So working as an agent. This is the job of an agent. An agent doesn't sell product. He sells the product on behalf of the principal. Further, there was another transaction. Furthermore, the petitioner also has hoardings and other spaces for putting up advertisement or marketing banners at its premises from which it generates revenue, and that during the course of the financial year 2018-19, the petitioner received hoarding and infrastructure charges from Reliance General Insurance in addition to the commission received on account of travel insurance. So what a suspicion is here?
No, but if your area of suspicion is Reliance, then you should have stuck to Reliance. For so far as Reliance is concerned, he has given you documents. Now, your allegation in 148.3 is all regarding prudent. Your 148A1 does not say a word about prudent. But all on a sudden, if you graduate to something which was not there at the show cause stage, how will he answer?
I had seen the name of the prudent, but I'm just unable to. I was searching for the name of on the list of the company number given in this document. I was searching for.
Because if you see the pages which he has, see if at page 162, the documents which you have shown. 154 at one place, yes, prudent insurance brokers is its name is there.
Other places also, my lord, one page 154, 158.
158 is also there.
Details of large marketing vendor. In the middle portion, left hand side, my lord. My lord, I found it in the middle portion, my lord. Left hand side. Twenty-ninth row, my lord.
Page
154.
154.
29th row, the Palmer Lloyd.
Both the placements mentioned, 154 and 162, the name of Prudent is mentioned as an intermediary. Today their order is that I have received money from Prudent. There is no transaction between me and Prudent. Prudent is an intermediary of Reliance. He is not my intermediary. And that is why, my lord, in the writ petition, but we've also annexed page 28. If my lord may kindly take, my lord, page 287.
My lord, suppose I am now is my turn. My learned friend should take his.
Yes, yes, Mr. Sharma. Let him conclude. Join him in reply. Yes.
And there the Prudent's name is also Palmer. My lord, what my learned friend is saying is inviting the writ court to appreciate facts. Whatever has been shown, these are the matter. My lord, at the time of negotiation of proceedings, the assessing officer should have reason to sufficiency correctness of this should has not to be gone into at this stage. For that, earlier there was no safeguard for the assessing. Reopening can be done only merely by issuing 148 notice.
No, but then after this,
after amendment,
no, before the amendment also, this judgment was there. Yes,
so my
GKN type shafts.
assessing officer, after evaluating all the materials which are available with
What
him,
was there in GKN has now been statutorily
Yes.
recognized.
the assessing officer, on the basis of materials available to him, has come to a conclusion.
But he is basically on page 87. Come to page 87. This is what he is supposed to answer. I will be looking only at this as a writ court. As a writ court, whether he was given a fair opportunity to present his case or not. Now it says companies through which transaction is made is Reliance General Insurance. Now come to the order 148A3. Findings, page 282.
Finding?
In the findings, you suddenly go to Wings Brand Group, Ajay Mehta Group. And then 284.
Paragraph, my lord. 283.
Yes.
Second paragraph here.
Yes.
As per information uploaded by the ACIT DCIT Central Circle 53 Mumbai, assessing company received 7 lakh as commission directly from Reliance General Insurance Company Limited.
So 7 lakh will not be the basis of inquiry. Basis of inquiry will be.
They've dropped at 7 lakhs. They're only on
7 lakh will not be the basis of inquiry. Basis of inquiry is this 1 crore. 7 lakh, so they will not reopen only.
This is the addition of both. Yeah,
No,
but amount
but-
is mentioned in the notice, 1 crore 9 lakhs.
So the 7 lakh they are not proceeding with, because you see at the end when the escapement of income is said, conclusion.
Yes.
6.3.
Yes,
It's
10
1 crore.
1 crore.
So 7 lakh is not in the picture. What is in the picture is prudent. Now, as regards prudent, where is the question? So he will answer a question only if a question is put. I ask him, what is your answer to 2 plus 2? He says 4. Your conclusion comes that 4 plus 3 should be 7. You have written 4. So you get 0.
So, Malik, on
So
this
this is
aspect, may I come back? Only for this. I will take instructions from the assessing officer
very well
to understand.
Yes.
To make myself understand so
very-
that I can assist me.
very well. Listen.
But if I may just make one submission, Your Lordship.
Your
Lordship, it is now, in fact, now there's a decision of the Honorable Supreme Court with respect to a writ matter, a matter under Article 226, wherein a decision of the full bench of this Honorable Court travelled up to the Supreme Court. The Honorable Supreme Court has held that if the material, the sufficiency of the material cannot be looked into, but whether the material is one on the basis of which the reason to believe that my learned friend said, whether that can be formed, that the court can inquire. And therefore,
Because
my
that
lordship,
is a
this
jurisdictional fact.
Because that's why, my lord, it is my humble submission that if reliance is the basis, then your proceedings are invalid. If prudent is your basis, you give me the point, because if my lord may kindly just take page 287 once.
Yes.
And I filed this document in the writ petition. It was never there before the assessing officer because I never had the opportunity. Now, this is, my lord, what prudent issues on behalf of Reliance. My lord may kindly take, my lord, after that amount 4,48,762 is mentioned, the line immediately after that. The check, demand draft, NEFT to be made in favor of Reliance General Insurance Company. So I have no transaction with prudent. And if they are mentioning them as
This in any case is factual. This will you will answer if you at all get a notice in respect of prudent. The question which we are to answer is whether a notice alleging that you had transactions with Reliance can hold you accountable for you having transactions with prudent if you at all had. This is the simple question.
Absolutely. And on the previous occasion I filed,
My lord has narrowed down.
This is it.
On the previous occasion, I had filed.
Yes, I have it. This Excel commodity.
And I would submit I'm on a better footing because there at least the transaction was known. In my case, the transaction is also not known.
Likhen. Heard Mr. Pratyush Chunjanwara, an advocate appearing for the petitioner. Full stop. Mr. Sharma.
So I have to come before my lord.
So in this one, come back, because if we don't get instructions, we'll proceed on whatever it is. We'll finish it off. Monday we'll finish it.
You have now the petitioner, but I understand, my lord,
Mr. Day is in some
Day is-
difficulties.
some difficult. But we take it up on 11th then. in fact.
ठीक है लिखे नहीं तो ऑर्डर
Your Lordship, this matter was heard earlier.
Your Lordship, my senior, Mr. Uday Shankar Bhattacharya, is on legs before courtroom number 36. I'm kindly praying for not today.
May I start, Your Lordship, and he can come? Or
will you be able to come? Half an hour is there.
Yeah.
Not today.
Your Lordship.
Not today.
Grateful, Your
Tomorrow.
Lordship. Thank you.
I'm for the petitioner, Your Lordship.
Customs.
Your Lordship.
Mr. Day was there.
Your Lordship, this matter is appearing for the first time.
Let us see. Nobody appears. I'll direct service. देखिए फाइल तो देखिए somebody had appeared on the last occasion through virtual mode. I find the name recorded.
Your Lordship. And
But she
Your
was
Lordship,
inaudible.
yes, Your Lordship had directed that they should appear physically.
What is the matter?
Your Lordship, the order in original has been challenged, Your Lordship. If Your Lordship takes the order impugned, it is at 178, Your Lordship. And Your Lordship, straight away the discussion and finding against me, Your Lordship, at page 207. So, Your Lordship, they have no, I had the case, this case, custom broker has been penalized for overvaluation, Your Lordship. So, when he filed his written notes, he specifically took the point that valuation is not the domain of the custom broker, and he cited several judgments. Your Lordship, if Your Lordship takes page 207.
Yes.
Your Lordship, someone is appearing for Union of India.
For the Union of India, led by Mr. Pranay Bhattacharya. And for the Union of India, led by Mr. Pranay Bhattacharya.
Mr. Bhattacharya.
Mr. Bhattacharya. Yes, my
He's
lord.
on legs.
Yes, my lord. He's on legs, my lord.
Who is appearing for the customs? Mr. Bhattacharya is
No,
appearing
no,
for the
no, my
customs. Customs is the answering respondent.
Yes, my lord.
Your written note of argument has not been
Your
considered.
Lordship, two points, Your Lordship. According to first point is Your Lordship, Your Lordship, I had cited 8 judgments showing to show that valuation is not the domain of the custom broker. It is between the importer and the exporter. They decide the price that is in the invoice. On the basis of that, documents are filed. None of those documents were considered. Your Lordship, if Your Lordship takes page 207, Your Lordship, where the finding against me is summarized, Your Lordship.
207.
Yes, Your Lordship. Your Lordship, paragraph 34 is the discussion and finding against me, Your Lordship. First, Your Lordship, they are in the first paragraph, they are quoting from the show cause. The role of Shri Sudipto Bose in the show cause notice, it is alleged. So, Your Lordship, this first paragraph is copied from they're summarizing the allegation against me from the show cause. Then, Your Lordship, paragraph 34.1.
They are dealing with the reply.
Reply, Your Lordship. Now, Your Lordship, if Your Lordship, I'll just place this entire paragraph, Your Lordship. In reply to the show cause notice, the custom broker Bose Enterprise, in his written submission dated 1/5/25, has inter alia stated that they are in no way concerned with the declaration of export goods and corresponding overvaluation. of the same, and that as a custom broker in a routine course of their business, they obtained the export processing job against 5 shipping bills through an intermediary, Shri Hariom Mishra, on the receipt of all the requisite KYC documents such as authorization letter, custom information sheet, signature verified by.
What has ultimately happened?
Yes, Your Lordship. Towards the end, Your Lordship, the custom broker also cited certain case laws and requested for withdrawal of the show cause notice. This is how he has dealt with the judgments I cited. Now, apropos to this, Your Lordship, I would take Your Lordship to my written notes, which is at, Your Lordship, relevant page is at page 173. No. 173, Your Lordship, paragraph 12. If Your Lordship would turn to the next page, continuation of paragraph 12. It is for the importer and exporter to ensure the correctness of the import-export declaration. Penalization of custom broker in such cases is not sustainable. I cited 8 judgments, Your Lordship. I would just cite the first one, Your Lordship, before Your Lordship, just to
Not
indicate.
required. Once let them. I just wanted to
Yes,
know
Your
the point. Very well. Let them come, because in any case, in
Your
their
Lordship.
absence.
And Your Lordship, I would like to cite certain judgments on this point itself, Your Lordship.
So it's basically on the point of violations of natural justice.
Your Lordship.
लिखे नहीं. Third, learned advocate appearing for the petitioner.
Your Lordship, I'm in the virtual mode. I would request Your Lordship will take up the matter tomorrow, Your Lordship.
Not today.
I'm deeply obliged.
My lord, come to the petition, my lord.
Yes, that matter.
Yes, my lord.
Setting of the amount refundable.
It's settled now.
No,
Why?
in my respect submission, because those 2 judgments by the court, our High Court has passed on different premises.
Yes.
First, the judgment of India was relied by the and in judgment, that has been placed on the earlier judgment of graphite India. So, I'm writing have a look at the graphite India. Page 6, madam.
Starts. Page 6. Yes.
I'm reading from page 2nd, page 7. On perusal of the relevant paper and consider the facts of this case, I am the view that the following difficult questions arise in this case. Whether include action of the assessing officer under section 45 of the Income Tax Act, the adjustment of the demand for the assessment year 15-16 with the refund for the assessment year 8-9 without considering and disposing of the objection of the petitioner against the information of the public adjustment under section 45 of the same type, without affording any opportunity for any to the petitioner and without passing a formal order of satisfaction that the assessing petitioner is not in a position to satisfy the demand for tax imposition and that amount cannot be recovered at all. Second, whether into action of the respondent assessing officer dispute of the whole amount of demand relating to 16 under section 25 to 45 of the Act, and which is admittedly in excess of 20% of the demand in of assessment year 8-9 during the pendency of the appeal against the assessment order for the without disposing and passing any formal order on the application of the petition. So So my lord, is basically on that when the SSC raised the objection that no adjustment should be made.
Makes an application under section
Makes
220.
an application. He has to first make an application for stay also for availing this 20% benefit.
So here he has not made an application for stay.
In the
under
present case,
226.
my lord, he has not made.
My lord, I have made an application. I have told my
226, I think he had
My lord,
kindly come to page number 39, my lord, of the writ petition.
Page number
39. My lord, this is the acknowledgement. I will read out the remarks part, my lord. Dear sir, please refer to assessment order passed under section 143.3 on 17th of April 2021, wherein your honor have made additions of rupees 8 crore 27 lakh and odd amount under various heads of Income Tax Act 1961 being aggrieved. We have filed an appeal before London CIT appeals on 3rd of August. We are hopeful of substantial relief. A copy of Form 35 and grounds of appeal are enclosed. Since the addition made by you is disputed in appeal, your good self is requested to keep the demand and penalty proceeding in abeyance till the disposal of.
To whom
This is submitted online on the income tax portal.
Application has to be made to the assessing officer.
My lord,
not to the
on the
CIT
portal,
appeal.
my lord, on the
And here,
portal,
my
the demand notice which are being issued,
Whether he-
I have replied.
He has not stated that he has
My
going
lord,
to deposit 20%.
My lord, kindly come to page number 38. This is the letter which we have enclosed with this. It is addressed to the AO only, my lord. Page number 30. My lord, my state application was filed. It was pending. I have duly made my compliance before CIT appeals also, my lord. They have recovered in excess of 20%, which they are not
So if
legally
they want to
entitled.
recover, they can recover 20%.
Even that, when there is no stay.
If there is an application, then you have to reject it and then proceed. Or if you have to recover during pendency of the application also, you recover 20% only, not more than that. That is what that is what the law
was
is.
made to understand. But in this case, my lord, I am citing one judgment of Delhi High Court.
Because that makes the law ocious. If he files an appeal and deposits 20%, if he deposits 20%, you will willingly stay, and if you are going to recover, you will recover more than 20%. The two are contradictory. The spirit of the law has to be understood. Spirit of the law is not that. Then we are paying only lip service to the statute. We are looking at the letter, not the spirit.
Paragraph 1781.
Here also 20% only has been adjusted, not more than that.
Held that Department can set off. I know
Only
that.
20%. Here also. See, let us read. See paragraph 15. The AO sent a letter dated such and such to the SSC requesting the SSC to pay a sum of rupees 69 and odd for covering up the shortfall of 20% of the disputed amount. Right? Now, this is the letter. The letter was, what does the letter say? It was proposed on behalf of your company that outstanding demand, that is 20% of 4 crore and odd, which comes to something. See, comes to balance recoverable demand, comes to 69 and odd. There was a suggestion in your letter for adjustment of refund of 2016. Refund of such and such has arisen after the order which was adjusted. So there was a collection of 29. Balance recoverable demand comes to 69 and odd. Now thereafter, admittedly, the petitioner had not deposited a sum of rupees 69 lakh and odd for fulfilling condition of 20%. What was recovered?
That amount was recovered.
Where do we get that?
Paragraph 18, my lord.
Doesn't show, it is confusing.
Since the SSC had not fulfilled the condition for securing a stay of demand, the entire demand in respect of 2020 remain outstanding. The same has since been recovered. The sales.
What is this same? This same is relatable to the demand or the same is relatable to 20%?
Demand is in respect to 70.
That we'll get at the first paragraph.
Can you come to paragraph 14, my lord? There is no caveat that it is also permissible to audit a specified percentage of the disputed demand by adjustment of the different assets. However, in the present case, the demand in respect of assessment of 1450 was subsisting on that when the demand was
Just a minute. What is our case? But our High Court has specifically said you cannot adjust more than 20%. I'll be bound by my High Court. It is specific. Danieli India is absolutely specific.
Danieli has followed that.
Not only followed, it has said. It has clarified what it meant by Danieli. If the court has understood it in a particular way, then I will have to differ and refer it to a larger bench. I cannot say that I will not follow this.
My lord, even
Because if
Delhi
you
High
see
Court.
page 2, last paragraph.
Yes.
The legal issue which the petitioner has raised in this writ petition is that if the respondent income tax authority can he recover more than 20% of the demand? This was the question.
Question was different, but the question was reframed in the course of making judgment.
Whatever, now this is judgment of this court.
Yeah, initially, even without intimation, earlier the question
And page 3, last paragraph. Action of assessing officer recovering amount in excess of 20% are arbitrary and not sustainable in law. You have to get it corrected by division bench, no? Because
now
unless
it cannot be done, my lord. This judgment is of 23.
लिखें